submission item number 1.
My lord, the question frame at page number 6, my lord. Well, I'm in VC.
Yes, yes.
Page number 6, question of law frame, whether on the facts and circumstances of the case, the learned tribunal is illegally has taken cognizance of the fact that by declaring the portion of sub-rule 3 of Central Excise Rule 20202 is inclusion that the section 37(1) of the Central Excise Rule 2022 gives the extensive power to make rules for achieving the objective of the Act, and Rules 83 of the Central Excise Rule 2002 is framed in accordance with the power delegated to achieve the objects of the Central Excise Act. And the second question is that whether the learned tribunal is correct to allow the appeal when the department has already filed SLP against judgment dated 27/11/24 in the Gujarat SCA number so and so. The case is still pending, my lord. So let the matter be disposed of till the disposal of the SLP, which is pending before the Honorable Supreme Court. Before that is still pending and final decision. Therefore, till the final outcome, the decision of Apex Court comes to the said SLP. The rule.
Correct. Notice returnable. April 20th April.
Item number 2.
My lord, the question frame at page number page number 12, my lord. That whether the fact and circumstance of the case, the Honorable Tribunal has added holding that the pen drive and the printout data retrieved from it cannot be considered as evidence under.
Correct, correct. Sir, by itself it's not evidence, sir, unless 65B and all is produced.
Yes, it can be. Then second question very important, whether cross-examination by the adjudicative authority is mandatory in all quasi-judicial cases.
Cross-examination by the authority?
Yes.
No, no. How can? Which authority? The authority himself wants to cross-examine.
Yes, my lord.
No, no, no. I think you framed the question wrongly, sir.
Then I'll frame the fresh question, my lord. Give me 1 week time, my lord.
At the request of Mr. Chimanka, counsel for the appellant, list on 22nd March.
Item number 3.
My lord, question is framed at page number 28. Whether the rule 83A of Central Excise Rule 202 is traversed. It is not important that whether C question, whether notice for recovery of area of Central Excise duty on account of defaulted payment of Central Excise duty amounted to 2 crore 65 lakhs.
All right. Notice returnable 20th April.
Much obliged, sir.
Item number 4.
May I please, your lordship? The matter relates to public interest litigation, my lord. 2 acres of government land has been settled with the name of the opposite party number 6, influencing the revenue authorities, my lord. Your lordship kindly see annexure 1. The land belongs to government, my lord. Nature of the land is abada jugya anabadi, which is in Odia language, my lord. Thereafter, annexure number 2, the land influencing the revenue authorities, the opposite party number 6 has converted this land into Ghoravari. Gajara Singh, who has been implicated as opposite party number 6 in this writ petition.
All right, all right. You say the petitioner's representation, which has been forwarded to the collector by the Revenue and Disaster Management Department, will be examined by the collector. And after notice to the petitioner and opposite party numbers on number 6, and after giving them a hearing, a reasoned order should be passed not later than 1st May and communicate to the parties not later than 8th May. The court clarifies it is not expressly.
A date may be fixed, my lord.
Item number 5.
Petitioner has filed a representation by annexure 1 before OP number 2, my lord. That may be considered within a stipulated time, my lord.
He had filed another writ petition.
What was the last date for making objections?
Another one, 1263, my lord, as the licensee was not made party, your lordship directed to withdraw and file a liberty given to file a better application, my lord.
No. Did you file an objection? You're asking for shifting, is it?
Annexure 1, my lord.
No, you're asking that the shop be shifted.
Yes, my lord. That is pending before OP number 2, my lord. They are not considering.
OP number 2.
OP number 2, my lord.
It is stated that the petitioner's request for shifting of the IMFL on shop.
Oh, that is Desi liquor shop, my lord.
Desi liquor shop of opposite party number 4 is still pending with the collector in Noapada, bracket opposite party number 2. Since November.
Yes, my lord.
Since 7 November 2022. A direction is issued to the collector to examine the said representation, and after notice the petitioner and opposite party number 4, and after giving them a hearing, to pass a reasoned order not later than 1st May and to communicate with the parties not later than 8th. The court clarifies it is not expressly.
Item number 6.
No instructions. 6, 7, and 8.
Item 6, 7, and 8. Item number 9.
Memo taken on the bottom.
Item number 9 may plead, my lord. Here I have challenged the impugned communication under Annexure 3. The amount which has been derived basing on the assessment and assessment order that has been set aside by this honorable court, my lord. I am forwarding with a copy of the orders, my lord. Basing on the case of automobiles.
This item number
9.
which is the writ petition number 7837.
Yes, my lord.
Your lordship,
Patro agency.
what is this? Prayer is some equitable mortgage, you know?
Yes, your lordship.
What is the prayer? Come to the prayer.
Nine is something.
Trade number 1 is by the impugned notice.
Department raised a demand.
Yes, my lord, under Annexure 3, basing on the assessment order, and that has been set aside by my lord on 1st of December 2021. my lord.
And they have attached the property.
No, my lord.
Tax department is attached the property.
My lord, that is
All right.
Against the same demand which is set aside by this court.
yes, my
Right.
lord.
It is pointed out that by an order dated 1st December
I've given 2
2021,
copies, my lord, of the orders.
Civil 18202 of 2015 bracket Messrs. New Patro Agency versus Assistant Commissioner of Sales Tax, and the similar orders in the connected writ petitions 14145 and 14146 of 2013 bracket Messrs. Jagannath Distributor versus Assistant Commissioner of Sales Tax bracket. The assessment orders on the basis of which the impugned demand has been raised
Under Annexure 3.
under Annexure 3 to the present petition already stands set aside. Full stop. Paragraph. In that view of the matter, the demand under Annexure 3 shall stand quashed. No further directions are called for in the present petition, and it is disposed of as such.
Your lordship, beg your pardon, your lordship. This demand, only this is the notice, your lordship. And in the pleadings, your lordship, prima facie on the face of the pleadings, it is pointed, find out that the demand is for two firms, your lordship. One Jagannath distributor and another New Patro Agency.
Yes, both these are. Have you not
Both,
given
I've given the copy.
Last page.
last page.
New Patro.
Right.
So
Publishment.
Item number 10.
Item 10 and 11 not pressed.
Not press dismissed.
Item number 12.
My lord, on behalf of Santosh Patnaik, senior lord, he is ill. My lord,
All right,
Murray taken next
the
week.
appellant is-
My lord, kindly see. I am appearing for the private assets. It's a very sensitive one. We have been suffering for last 2-3 years at the instance of some persons who have absolutely no right title interest over the land in question. I will just take 2 minutes of your lordship and quickly submit what is the matter. This particular land, a particular piece of land admittedly belongs to BMC. And there was a litigation between my clients and the BMC. Ultimately,
There is no stay
BMC
granted.
No, that is what I'm saying. Let him take time. But by filing this writ appeal, they are not allowing to implement the order of the...
No, you say that. You say...
So, your lordship may clarify.
Yeah, repeated adjournments have been sought in this writ appeal on 4th May, 4th July and 3rd November 2022 on behalf of the appellant. Full stop. Even today, another adjournment is sought. Paragraph. Mr. D.K. Manthi, learned additional government quit.
No, my lord, on private capacity, I am appearing.
Mr. D.K. Manthi appearing for...
Mr. Mohanty is for BMC. And BMC has not challenged this decision. The direction is against BMC. BMC is not in the appeal.
No, whom are you appearing for?
I am appearing for the opposite part number, respondent number. I am just... Yes, my lord. 1 and 2.
Mr. D.K. Manthi appearing for respondents 1 and 2 points out that on account of the pendency of the present writ appeal, the appellants are not permitting the implementation of the orders challenged in the writ petition civil 24420 of 2019, which was dismissed
by BMC.
By the
no, my lord, writ was allowed. I was the writ petitioner. My lord, kindly, just 1 minute, my lord.
By dismissing,
yes.
All right. The impugned order, not allowing the implementation of the impugned order dated 30th March 2022 of the learned single judge.
Yes, my lord. My lord, what is the impugned order? 1 minute only. The impugned order was direction to the BMC to implement the decision in letter number 127 dated 29/1/2019, wherein it is decided that the road will be provided to me from the company. That decision may be implemented, notwithstanding
he points out that the effect of the said decision is that the decision of the Bhubaneswar Municipal Corporation
in letter number 127
dated
29 January 2019, Annexure 6 to the writ petition.
Bracket Annexure 6
to the writ petition.
To the writ petition for laying of a road should be implemented. Paragraph. It is clarified that the mere pendency of the present writ appeal will not come in the way of implementation of the above decision of the BMC.
Great.
Of course, the full stop. Nevertheless, the implementation of such decision would be subject to the outcome of the present.
Yes, Mike. Yes. Lordship may give them long
list on 18 September.
Item number 13.
There is an IA for withdrawal, your lordship.
All right. The IA is allowed, dismissed as withdrawal. All right.
Item number 14.
Yeah, please, my lords, instructions to appear in this item number 14, 15, and 16, my lords. And in fact, I was checking up, there's no delay. Inadvertently, IA has been filed for continuation of delay.
All right. All these three applications for delay allowed.
Right. And my humble contention was I just want to reframe the questions of law.
All right. At the request of Mr. Kar, list these appeals on.
Hello, I am appearing all the three cases.
5th July.
Sorry,
5th July.
5th.
I am appearing all the three cases.
All right, sir.
Thank you.
Item number 17.
14, 15, 16. See.
Item number 17.
My lord, I'm appearing for the appellant virtually.
Yes.
My lord, this honorable court has posted this matter on 27th March 2023. Wide order dated 2nd January 2023.
All right. List on 27th March. All right.
Okay, sir.
Item number 18.
May I please, ma'am? Here, my lord, the question is framed even page start from page 10, but I'm also your lordship has passed against the department while in Delhi.
That's right.
But that judgment is pending with the Honorable Supreme Court now.
Stayed by the Supreme Court?
No, stay is not batch of cases, not only these cases, batch of cases pending.
I know.
And your lordship
pendency is not enough, sir.
Yes, there are. Your lordship notice may be issued on this. No, I'm not bringing your lordship in usual cases when they're pending. Your lordship has issued notice.
All right.
In my case and state case, no. I'm just applying that.
The counsel of the department points out that although the issue urged by the department stands answered against it by the judgment of the Delhi High Court and Adani Wilmar Limited versus Gujarat.
I'm also passing your lordship judgment. Your lordship interpreted the circular as a binding or not?
14D, Rule 14D. In Principal Commission of Income Tax versus IL&FS Energy Company Limited, MANU/DE/5751/2017. The said judgment has been challenged by the revenue in the Supreme Court of India, and the SLP stated to be pending. Is a notice returnable.
Here below Kerala High Court in favor of the department. Sorry, can I take that?
Right.
Delay, your lordship, 20 days delay.
Delay control. It's a notice returnable 14 September. 14 September. All right.
Much appreciated.
Item number 19.
19, my lord, I pray 1 week time to remove defect, my lord.
All right. List on 15th March, defects be removed.
Item 20.
19 to 23, my lord, same.
All right. Same.
Item number 24.
Obliged.
May I please, your lordship? I'm in virtual mode, please. My lord, the matter is regarding inaction of district administration of Sonpur over a long pending representation of the villagers of Taraikala, praying for eviction of encroachers from the public Rakhit land. And my lord, this Rakhit land mostly consists of...
the encroachers are not named, sir, in the petition.
My lord, this is encroaching piece by piece. No specific person is there.
No. There will always be some persons. You have to find out. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation, naming the encroachers.
My lord, my prayer may be for
Following
representation.
such representation to seek appropriate remedies in accordance with law. Disposed of is withdrawn, the liberty is paid for.
Obliged.
Item 25.
And government, now copy served, it is a PL nature. The suit land is government land under the definition of OGLC Act. Now the OP number 3 is going to make market complex and obstructing the only passage of 3 panchayat villages. I have given representation under Annexure 7 and 9.
All right, sir. The petitioner's representation, bracket Annexure 9, shall be examined by the collector. Paleshwar. And after notice to petitioners and officer party number. Who's going to construct the block?
OP number 3 is the video.
Video is constructing something.
Yes, madam.
All right. And opposite party number 3. And after giving them a hearing, a reasoned order should be passed not later than 1st May and communicated to the parties not later than 8th May.
Before OP number 2. Yes.
The court clarifies it is not expressed.
Item number 26.
My lord, the State Commission for Protection of Child Rights is paralyzed because all the 6 posts of members are lying vacant, my lord. Since 2020,
Why set up bodies if you can't fill up members?
Yes, ma'am. It should ideally
You're
be
killing
filled
all
up,
the
actually.
tribunals this way.
As I'll take instruction, my lords may give a short date. I'll take this time.
Even the, my lord,
grievance made in the present petition is that all 6 posts of members of the Orissa State Commission for Protection of Child Rights has remained vacant since
2020. I have mentioned
since
2020 4 posts, 2021 1 post, 2022 August 1 post. But the rules.
So you say that 4 posts of members will be lying vacant from 19 May 2020, 2 posts from 10th January 2021 and 25th August 2022, respectively. Paragraph, this being a statutory body, there appears to be no justification for keeping these posts vacant Full stop. The only result can be the defeating the very purpose of such a commission. Paragraph. Notice, Mr. Manthi accepts notice on behalf of the opposite parties and seeks time for instructions. List on Ninth March. 9th March. Obliged.
Item number 27.
I'm filing this PL for the J reliabilities and I'm praying for issue instruction to DG police that why he has not permission to his grievance and why the J reliabilities Western Odisha jails, all jails.
Sir, enough PIL, sir. We are dealing with, I don't know if you're aware. Have you seen the hearings we are conducting on these prison matters? Are you seeing that?
Yes, sir.
Are you aware?
Sir, I am already filed in the first petition, which is I'm praying for a take the petition is 3809.
I don't think you're following the question I asked you.
Sir.
Are you following the question I have asked you just now?
Yes, sir. Tell me.
What is my question?
Please again, sir, please.
आपण जानते कि जेल मैटर गुड़ाका अन्य पीएल रे डील करा होची ओडिया बुझछन त
आगे
ओडिया
आगे
कन्वीनियंट
आगे
He is a qualified man, Dr. Sunil Kumar Rath.
maybe but
are you watching these live streaming proceedings? He's not
last week perhaps jail matters we have dealt.
Jail reformation ro jo case chalchi apan dekhuchanti dekhin. He has not seen.
Please see those live streaming hearings. All right.
Yeah.
Then you will understand that we're already dealing with these matters very extensively. Have you seen all the orders that we have passed?
Sir, please take the petition with.
Again, asking the question.
Please.
अपन देखो you follow that jail matters which we are dealing with.
Okay, sir.
This bench only is dealing with the jail PL matter.
Okay, sir.
You get the number and you read the orders uploaded in the website that they are available in website.
Okay, sir.
This court is already dealing with the issue of improvement of the prisons in Orissa in other PILs, and elaborate orders have been passed. So the petitioner appears in person, expresses ignorance of either the pendency of those PILs or of the orders of the court. Full stop. There is no need to multiply further petitions on the same issue. The petitions are accordingly dismissed.
Item number 28. Item 28.
Password.
29.
May I please issue? But in this public interest litigation, the petitioner has raised certain lordship checking affairs of the state in misinterpreting the government policy. One officer of the state lordship officer of the state has demolished the government establishment and has constructed a 3-star hotel there in lordship. Lordship kindly see Annexure 2 lordship kindly for a moment. By virtue of policy decision, the state government took a decision lordship to lease out the tourism establishments to the private bodies lordship. And lordship kindly see page Annexure 3, page 35.
Come to this Annexure 7.
Lordship.
Page 152.
152 lordship.
Where is the proof of service of this?
Sorry, lordship.
What is that L/C? I don't know what that is. No stamp, nothing.
152.
Lordship, that below the receipt, lordship.
All right, the petitioner's representation packet annexed to 7 series.
Lordship, it cannot be Lordship. I made allegation against the secretary Lordship itself, Lordship, kindly see. It cannot be Lordship. Can they Lordship, they will demolish the government establishment and they will construct a government like a 3-star hotel?
All right.
Lordship, that is the subject matter.
Examined by the collector Jarsogoda and after notice to the petitioner and opposite party 9 and after giving them a hearing. A reasoned order should be passed not later than
Lordship, may make a one submission.
Parties not later than 15th May.
Lordship, my allegation against the Lordship can additional secretary. Collector cannot Lordship. Either chief secretary Lordship or Lordship will decide this matter. Lordship, kindly allow me 1 minute. What they have done, such illegality can Lordship will allow. Lordship, kindly see the state policy, the state government took a conscious decision to leisure the government establishments, Lordship, for management. And this officer direct Lordship to the private body to demolish the government establishment and to construct a 3-star hotel to the government land. Lordship, kindly see the Lordship just to come to this. I am just placing a sequence weight. Lordship, kindly to Annexure 3, the agreement. The Annexure 2 is Lordship the state government's decision. And Annexure 3 Lordship kindly see page 35. And Lordship kindly see page 36. Just I am reading Lordship. B. Department of Tourism invited bids for upgrading, developing, operating, maintaining, managing, and transferring the project of tourism accommodation at TS Jharsuguda, a specified number such and such Lordship, and according to these measures, Mayfair Hotels and Limited could succeed in the rate application in the bid Lordship. Then Lordship kindly see page 39. Page 39, clause 1.122. This is the OM means operation and maintenance. The specific assignment of the agreement was only will maintain the establishment. And let's look kindly to 1.127. Project means upgradation, development of tourism accommodation unit at TS Jharsuguda. Only will upgrade. Then let's look kindly see come to let's come to 70, page 73, 1.596. No demolition of the project facility in part or full shall be allowed during the last 5 years of the lease period unless specifically approved by DOT. And Lordship kindly particular what they have done. Immediately after Lordship getting this agreement, this OP number 10 Lordship on 25/4/22. But applied for town planning Lordship permission for construction of 3-star hotel. And particular Lordship kindly state I come to page 122. These are the sucking affairs Lordship, page 122. On 18/5/22, this Director and Additional Secretary Government directed to demolish the existing building, which has been constructed by investing more than 6 crores. And that is the existing building of the TS Jharsuguda. And this agreement for only to maintain the establishment and to make maintenance. And Lordship, without any approval of the state government, this authority, in conniving with this hotel group, hotel owner of the hotel Lordship, directed to demolish the entire establishment. And Lordship, 18/5/22, he directed to demolish, and Lordship, page 124, on the same day, is directing Lordship to demolish the existing TS Jharsuguda. On the same day, saying, you change the nature of the status of the land. And Lordship, particular Lordship, can you see this direction on 18/5/22, till that no status has been changed, still in the government land. And the Lordship, kindly see the annexure Lordship 4.
What happened after 18 May?
18 May, Lordship, the hotel is still going on, Lordship. The construction, they have demolished the existing building.
What were you doing for the last 7 months?
Lordship, to get all those documents, I have tried my best, Lordship. And I'm tried my best, Lordship, and I obtained all those documents on RTI. Then I have to this honorable court without any basis, Lordship. Timing is saying, go and make a research and collect document, then you approach the court. And I have, Lordship, travel all the forums, Lordship, and I got the entire document. Then I approach the Lordship.
What is the date of your representation?
Lordship, kindly, Lordship. That is 3/1/2023, Lordship. 3/1/23.
So let them hear you, sir. Let them pass an order, you come back. If you're unhappy with that order, you come back.
Then Lordship say to Chief Secretary, how the collector say, Lordship, I am additional secretary, Lordship.
It doesn't matter, sir. He has to objectively take a call. What is this? He's the highest authority in the district.
No, but my allegation against OP number 2, Lordship, he is the additional secretary, Lordship. Can collector deal with the matter, Lordship? Lordship say to Chief Secretary, then I will upload to the Chief Secretary, Lordship. Because Lordship, the state policy, can the Lordship with government land and in violation of all the statutory provisions, can they construct a hotel, Lordship, 3-star hotel over the government, Lordship? Kindly for a moment, Lordship, kindly see page 28, page, Lordship, page 26 for a moment, Lordship.
Yes.
Page 26 is just the photograph, Lordship. It has come out related to hue and cry has made in the state, Lordship. If they enter building, they have demolished this building, Lordship, which is yet to be open. They have invested more than 6 crores, and this is over government land. And let's say these officials can all the demolish the hotel and will construct 3-star hotel. And let's say by this violation of public policy, a officer cannot rule over the state, Lordship.
We'll have to know the complete facts, sir.
Lordship, then Lordship, they should file a reply, Lordship. This is very sensitive issue of the state, Lordship.
What are your instructions?
As this is on a government land. There was a building, Millards. Now this particular hotel, Millards, has come up. The construction is over. In fact, during the hockey World Cup, Millards, as per the records, they have already hosted Millards. There were people staying there. And the clause
the whole thing is over.
Yes, Millards, it's over. It's functioning, Millards. It's over, my lords. And my lords may see his pleadings at page 20, at para 20. Sorry, para 21. That it appears now, at page 20, that it appears now the opposite parties have completed construction of hotel in misutilizing the name of hockey, and any moment the hotel will run in view of the judgment of the Honorable Apex Court. So it's the construction is over. And he waited for 6 full months, my lords, before filing his representation.
That's what.
Repetition of 1st January, Lordship. This is
10th February, sir. We come to page 24.
24, Lordship. 24, Lordship.
Page 24.
Page 24, these are paper clippings, Lordship.
No, just show me the
page 24. Sorry, Lordship.
Judges are always wrong, lawyers are always right.
No, Lordship, they have to rectify.
See it, sir. See it. What's the date you are seeing?
10th February, Lordship. 10th February, Lordship.
That's when you filed it.
Yes, Lordship.
Not January. Not January.
No, my representation,
Lordship. Trying to say, when did you file he's talking about when you filed the petition.
Lordship. Lordship, on this ground, Lordship, it cannot be entertained, Lordship.
Not for that.
I am not an entry matter, Lordship.
You may be amused, sir, but this is a valid point he's making, that you waited for 6 months to file the petition.
Definitely, Lordship. I have to collect the entire document. Lordship, once you are appraising my plain dependency, Lordship, you have not done nothing. And we have collected all those documents from the authorities, Lordship. And Lordship, no one that doing an illegality. It is how we are facing difficult to get certain documents. And all the documents we have obtained on the RTI. And after confirmed regarding the decision of the state government and regarding decision of this officer, I have to this honorable court. But can I make an allegation against a senior officer of the state, as of the state, without any basis of documents, Lordship? I have collected all those documents from the different angles, Lordship, and I confirm that the gross illegality, that the misappropriation of crores of rupees by this officer and is the connivance by this officer in the hotel group, then Lordship, I approach your Lordship because it is public interest involves. Otherwise, I can't, Lordship, I approach your Lordship by throwing a paper that these are the allegations. And Lordship, kindly say, it is on the face of it. How can an officer can do it, Lordship? By demolishing a government building of more than crores. And my friend is stoutly saying that we have constructed a hotel. Can they not encourage a private body to demolish a government land, government establishment, and to construct a hotel there in, Lordship? Because he's a big man, because he is politically and money and muscle man, Lordship, of the state. And all the Lordship, the state is Lordship, the Lordship kind of paper clippings. The news has come out in the front line of every newspaper, Lordship. Then I ascertain all those facts, Lordship, from the different authorities. Then I approach this honorable court, Lordship. It is public interest involves, Lordship. Can these officers rule over the state for the years, Lordship?
All right.
They should file a reply, Lordship.
the allegation in the present petition is that a tourist facility which was being run by the government of Orissa in Jharsuguda, is it? Where is this?
Jharsuguda, Lordship.
In Jharsuguda, has been handed over to a private entity. Bracket opposite party number 9, bracket. Under an agreement under an agreement in terms of which opposite party number 1 was to operate and maintain the facility. But in the garb of doing so has demolished the facility and erected a hotel in its place. Full stop. The allegation is that this has been done illegally. Full stop. Paragraph. Mr. Mahanti, learned additional standing counsel for the state, informs the court that the hotel that has come up in place of the earlier facility was in fact operational, is now in fact operational, and was also utilized during the time of the World Cup hockey, which was hosted in state of Odisha. Paragraph. Without at this stage expressing any view in the matter, the court directs notice to issue. Full stop. Mr. Dalai points out that since the petition contains specific allegations against the incumbent state government official who is impleaded as he has been impleaded in person as opposite party number 2. Full stop. He said notice, Mr. Mahanti accepts notice for opposite parties number 1,
3, 4, 5.
3, 4, and 5. Full stop. Notice will issue to the other opposite parties by speed post. Returnable on the next date. Full stop. The petitioner is permitted to serve them dasti and all right. Replies will be filed within 4 weeks of service of notice, and rejoinder that too before the next date. Before that, you just say, Mr. Dalai further points out that since the petitioners had to apply under the Right to Information Act, bracket RTI Act, to obtain relevant information regarding the entire project, they were unable to file the writ petition earlier. Full stop. They did make a representation on 10th January 2023 to the Chief Secretary.
Lordship. No, the representation was in fact made to the collector.
No, Chief Secretary also. Copy to Chief Secretary. Next, come to Secretary.
Okay, to the collector with a copy to the Chief Secretary.
Chief Secretary.
3rd January.
That is not on record, my lord.
No, Annexure 7 release.
Lordship.
Mr. Dalai, it was 3rd January.
Is that Annexure
3rd January, Lordship. 3rd January, Lordship.
There is no copy to the Chief Secretary.
All right.
So,
although they made a representation on 3rd January 2023 to the collector.
To the collector.
All right.
No, Lordship, that is 2 Chief Secretary, Mukhya Sachiva, Lordship, in Oriya. That Chief Secretary, Lordship.
Okay. To the Chief Secretary. Till date, no reply has been received to the said representation. Full stop. The petitioners are also not hopeful that the collector will be able to examine the matter since it involves allegations against the additional secretary to the government of Odisha in the tourism department. And then you say without expressing it at this stage, notice and then list on. Twelfth April.
Grateful, Lordship.
Item number 30.
You're back. What happened?
Same day, the day your lordship delivered the judgment at 10:30, same day, hardly the ink had not even dried. Order has been passed, re-energizing the same person, same bank, same officer by the administrator, same day. And in violation of same provisions of law. Undermining the judiciary and judgment passed by the son of the court, my lord. Have no regards of it. Kindly see, my lord. But I'm sort of language to say, my lord, how can they take on the judgment passed by the son of the court in the way they have taken? 10:30 judgment passed, same day passed the same order. Kindly see page 69, man. Lord, Lordship's judgment only I'll cite, my lord, para 29. Lord, what can we say it? Page 63, man. Para 29. Your Lordship in clear words have said that prior approval of 35(1) as required is mandatory. That is required to be taken. At least that your Lordship has been pleased to hold it. Now your Lordship may see page 21 what they have done. The judgment is 25th of January 2023. The order passed on 25th of January 23. The administrator first passes a resolution that is at page 25. And this administrator is also has no capacity to remain because in terms of section 32(1) Roman 4, after period of 1 year, this administrator period is lapses. He, after 2021, he cannot continue. That's already settled by this honorable court in very recent judgment. Kindly see, my lord. The administrator even is not validly continuing. Kindly see the judgment.
No appeal has been filed against the judgment.
No appeal filed.
No, they will know.
No appeal has been filed for us.
The bank.
No, that's
Judgment, the administrator even cannot continue after 1 year period. Then he is illegally continuing.
I don't know.
Just give us our judgment.
Yeah, judgment I have annexed, my lord.
Oh, I see. All right, correct.
That starts from
right.
The judgment of the lordship starts from page
49.
49, correct.
49, correct, grateful. And relevant portion is at page 63, my lord, with regard to Banking Regulation Act.
All right.
Para 29.
All right. The challenge in the present petition is to an order dated 25th January 2023 issued by the administrator of the Odisha State Cooperative Bank Limited appointing engaging opposite party number 9 as Managing Director of the Orissa State of the OSCB Limited, on terms and conditions as applicable to retired government servant, till the post is filled up in due course. Paragraph. Interestingly, on the very date that the impugned order was passed, this court delivered its judgment in writ petition civil PIL number 8927 of 2022 filed by the very petitioner, questioning, an identical order, a similar order dated 2nd March 2022, is it? Yes. Issued by the GA department, re-engaging this very person as MD of the OSCB. Full stop. While quashing this court by the said judgment also quashed the consequential order dated 7th March 2022 issued by the Joint Registrar, Cooperative Societies. Paragraph. Mr. P.K. Rathal, on counsel appearing for the petitioner, points out that the Registrar Cooperative Societies has further issued an order dated 25th January 2023. Approving such appointment in exercise of the powers under section 28(3-B)(1) of the Odisha Cooperative Societies Act 1962 (OSC Act). To enable opposite party number 9 to discharge the duty of Chief Executive Officer of the OSCB Bank as Managing Director. Full stop. This is identical to the order that was quashed to this court by the aforementioned judge. The petitioners also questioned another communication addressed on the same date, that is 25th January 2023, by the Principal Secretary to the Government of Orissa, from a Cooperation Department and Administrator, OSCB, to the Regional Director, Reserve Bank of India, RBI, seeking approval to such appointment under section 35. Sorry. Seeking approval of the Reserve Bank of India to such appointment. So it may be noted here that it is judgment dated 25th January 2023. This court had specifically held that there had to be single court's previous approval of the RBI. Under section 35(B)(1)(B) of the Banking Regulation Act to such appointment. To stop, this court had also held that there is no power in the Registrar Cooperative Societies to approve the re-engagement of such person as CEO/MD of the OSC Bank under section 28(3-B)(1) of the OCS Act. Stop. Paragraph. Interestingly, in the above writ petition civil PIL number 8927/2022, after the final arguments were concluded, judgment to reserve. And it was specifically indicated that the judgment would be pronounced on 25th January 2023. I think the order said that. The order.
25th January. Yes.
I think it fixed a date for orders.
Date of the impugned orders.
No.
Earlier order.
Not fixed, is it? All right. I see.
Hearing is concluded.
I see.
No. 47, page 47. Earlier order is at page 47. It's 2nd of March 2022.
No. You see, they had heard the arguments finally on 17 January 2023. And the orders were pronounced at 10:30 a.m. on 25th January 2023. Full stop. Yet none of the impugned orders impugned in the present orders, all dated 25th January 2023, impugned in the present petition, mention the fact that the earlier engagement of opposite party number 9 as MD/CEO of the OSC Bank was subject matter to challenge in writ petition civil (PIL number 8927 of 2022. The impugned orders seek to precisely carry out the same procedure which was held illegal by this court by the aforementioned judgment. Paragraph, when specifically asked of government counsel appearing before the court whether the said judgment is subject matter of any further challenge, they answered in the negative. So, you see, notice, Mr. Malti accepts notice for opposite parties.
One, two, three, and 4.
1, 2, 3, and 4. Notice to the remaining respondents by registered post, speed post. Returnable on the next day. The tracking report will be placed in record.
Well, as Mr. Matthews will accept notice on behalf of his
Opposite party number 8, the bank.
He accepts for opposite party number 8. The court is of the prima facie view for the reasons noted herein before, that the impugned orders are in gross violation of the provisions of the of both section 28 3B bracket 1 of the OSC Act, as well as section 35 capital B of the BR Act, and in teeth of the judgment passed this court on 25th January 2023, quashing an identical order of re-engagement of the very same person, that is opposite party number 9, as MD of the CEO of the OSC Bank. The court is therefore constrained to stay all the impugned orders, stay the operation of all the impugned orders forthwith. The result will be that opposite party number 9 will hand over charge forthwith to the registrar of cooperative societies. And this arrangement will continue till further orders. List all. See, replies be filed within 4 weeks of service of notice, rejoined of first. List on 6th April. Does the copy of this order be communicated by the Registrar General to the Registrar of Cooperative Societies?
Yes.
Forthwith. Just ask somebody to come. I believe.
Item number 31.
Prevented from sufficient cause from attending the assessment proceedings with the opposite party number 3, and the service tax demand has been made, my lords. And the sufficient cause, my lord, is that the show cause, which was given, my lord, is during the midst of COVID-19, my lords. And if your lordship would kindly turn to page 20 of the order. I'm sorry, to page 19 of the order. The show cause notice, my lord, is given, my lord, on 22/12/2020, my lord, at page 18, last. Lordship got it, please?
Sorry, which page?
Lord, page 18, my lords, of the part of this, the part of the order, my lords.
Right.
Paragraph 2.3.
Last two lines.
Last two lines, your lordship would get that the show cause was issued on 22nd of December 2020, my lords. Then, my lords, because of this COVID-19 situation, I could not reply to it. And also nothing happened, my lords. Thereafter, my lords, at page 20, your lordship would appreciate 5 personal hearing notices were given to me, my lords. And unfortunately, my lord, in this additional affidavit, and I've also annexed the medical papers, my lord, the lady met with an accident, my lords, and she was hospitalized, operated upon, and a series of operations were being undertaken, and she was advised complete bed rest. And that matter continued till 14/12/2022, my lord. At page 11 of the additional affidavit, my lord, I just, for your lordship's kind convenience, my lords, made out a chart, my lords. She was discharged and again
admitted. You just say an additional affidavit has been filed today by the counsel for the petitioner with a copy to.
I've already served a copy on my
counsel for the department. We'll stop in this affidavit. It's explained that the petitioner faced a serious accident in Berhampur town on 28th March 2022, fracturing the right hand wrist and other multiple injuries, and was able to be discharged only on 30th March 2022. Stop again, she was admitted for surgery to the hospital on 24th May and discharged on 25th May 2022 and advised bed rest. Stop. The treatment continued till 29th September 2022. Stop it. It is sought to be explained that for these reasons, she was unable to comply with the notices of personal hearing issued by the adjudicating authority, whose order dated 29th November 2022 stands challenged the present petition. Paragraph. Notice, Mr. Satpathy accepts notice. Reply be filed both to the petition as well as the additional affidavit within 8 weeks, rejoinder for the next week. Till the next date, no coercive steps should be taken.
Let's go on. I was only humbly praying, my lord, if your lordship would Give me another chance so that I can file my show cause and appear before the authorities.
I know, but you want to file a reply, I thought.
No, sir. My
Unless
learned
he's
friend, my lord, my
agreed to
learned
send
friend.
her-
Lord, month of March will take some time, Lord. First week of, second week of April, Lord, I'll file.
Right. 4th May. 4th May.
Because I was only praying it for another chance of hearing.
That's what, but he has to agree. Without his agreeing, then we can't.
He's fair enough.
First date, we can't insist that he should agree. All right.
No coercive action.
I have said that.
Obliged, my lord.
Item number 33.
May it please the Lordships? Lordships, in item 33 and 34, in both the matters, the petitioners have challenged the order of the first appellate authority under the GST Act. The Lordship may be pleased to pass the standard order.
See that 1020.
1020.
Same order. Same date.
Item number 35. 35.
May I please, your lordship. Lord, one defect I already, that is the not serving a copy, already supplied to my learned senior, my lord. It is the case, my lord. Yes. Lord.
Date will change to 23rd of 23rd of. Sorry, 24th August. 24th August, not 21st August, 24th August. All right.
My please, Lord. My lord, in respect of defect, I already served to my learned senior copy, my lord. And in respect of case, my lord, your lordship, this as per the section 62 of the GST Act, if he not filing the return, there will be assessment order will be passed, my lord. And if he 62 subsection 2, my lord, provides if you file return within 30 days, then the assessment order will be withdrawn and except apart from the penalty interest, my lord. Here the order was passed, my lord, 29 September 2020, my lord, under Annex 1. Under section 62, Lord, he filed return on 12 October 2022. Lord.
This is 3875.
4092.
Sorry, which is the item number?
35. Sorry. Yes. Lord, so Lord, as per the 62, if any person Lord, not file return, there will be assessment order will be passed under section 62, your lordship.
Right.
And the return will file within 30 days, then the same assessment order will be withdrawn, your lordship. And the instant case, my lord, 29 September 20.
Item number 36.
Item 36 not pressed.
Dismissed as not.
Item number 37.
Item 37, my lord, the petitioner has filed this writ petition challenging the process initiation for grant of license, on-shop license, without considering the objection filed by the petitioner, my lord. My lord, I request the lordship to kindly turn to page 15, my lord.
Was the objection filed in time?
Yes, my lord.
15. Page
15, that is inquiry report submitted by the Inspector of Excise, Other Police. Kindly see, my lord, para 8, violation of restrictive provisions. The Inspector of Excise clearly stated that the proposed site is violate Rule 26 and further submitted that since the proposal is defective, this may be considered for taking further course of action at your level. But without considering the same, the matter has been referred to the Excise Commissioner, my lord. And the Commissioner fixed a date for hearing without provide opportunity to me, my lord, only to the nearby OPSOP licensee.
And then what happened?
And thereafter?
Thereafter, the matter is pending before the Excise Commissioner. I request your lordship to direct the Commissioner to provide opportunity of hearing to me and consider my objection, my lord.
I don't know what is the stage before the excise. Because we are
only yesterday the matter was fixed for hearing.
If it is not referred to the government, Excise Commissioner can be directed.
Correct. The grievance of the petitioner is that although objections have been filed by the petitioners on 7/12/2022 pursuant to the Form 8 notice dated 24 November 2022, the Excise Commissioner is proceeding the matter, fixing a date of hearing without intimating the petitioners. The apprehension is that he might make a recommendation to the government without hearing the petitioners who have filed their objections. Paragraph. If the Excise Commissioner has not yet made any recommendation to the government of Orissa in the matter of grant of on-shop license in favor of opposite party number 5, then the Excise Commissioner will do so only after hearing the petitioners and considering their objections. Full stop. The petitioners will nevertheless appear before the Excise Commissioner on
short period because the excise year going to be end with it.
Correct. On 27th February,
yes,
at 11 a.m., along with the downloaded copy of this order. Full stop. The court clarifies it is not expressed any view in the matter.
Obliged.
The petition is disposed of. A copy of this order be sent to the Excise Commissioner for. All right.
Item number 38.
My lord, similar case has been finalized. Direct order. Sarat Parade case.
What is this?
Same order. Just, I think the date has to be different, or this is all connected matters?
My lord?
They're all connected matters. Same.
Yes, my lord. Yes, my lord. Sarat Parade.
Same order. Same order. Same date.
Item 39.
May it please your lords. Here, my lords, the claim of the respondent was repudiated on the ground of pre-existing disease and suppression of material fact, my lords. The Honorable Single Judge has discussed the matter, and finally, and it was without
deciding the fact that whether the disease was pre-existing.
Anyway, how are you amenable to the writ jurisdiction? You're a private insurance company.
My lord.
How are you amenable to writ jurisdiction? You have not raised that point.
My lord.
You have not raised that point.
Yes, before the Honorable Single Judge, my lords, I have raised the point.
That you are not amenable to writ jurisdiction.
My lord?
That you are not amenable to writ jurisdiction. Have you raised that point?
No.
Okay. All right. So why should, what is wrong with the impugn order then?
Here, my lords, admittedly, the appellant insurance company has established the fact that there was the disease was pre-existing, and by suppressing the material fact, this policy was obtained, my lords. Because the petitioner was advised for rasterly repair on 2nd of January 2019, and suppressing the said fact, proposal form was submitted on 29th of January without disclosing, and on the requisite column said no, and thereafter this policy was issued. After issuance of the policy on 15th of May 2019, operation was done, and all those facts have been noted by the Honorable Single Judge, my lords. Thereafter, the Honorable Single Judge said that whether the operation which was done on 15th May 2019 was for the rasterly repair, as has been advised on 2nd of January, directed me to file certificate, my lords. Your lordship may kindly have a glance, page 7, my lords. Here, the controversy between the petitioner and the insurance company has narrowed down to whether operation undergone by the petitioner's son on 15th of May, described in the operation note at page 6 of the petitioner additional affidavit dated 13 November 2021, was or was not rasterly repair procedure. Final opportunity granted to the insurance company on 15th August 2022 was for it to obtain certificate from heart surgeon certifying that the particulars of the operation mentioned in the document, including rasterly repair, the insurance company has disclosed expert opinion on the procedure undergone by the petitioner's son, saying the operation undergone was addressed and the same pathology would be addressed by the rasterly repair. And accordingly, one opinion of heart surgeon was obtained by the petitioner insurance company, and the same was filed as additional counter affidavit. And in the opinion, the heart surgeon has stated, my lords, that is in page 4, I opine that both rasterly repair procedure and the procedure performed on the child are for the correction of congenital cyanotic heart disease, tetralogy of fallout with pulmonary artesia membranes, which procedure is ideal for the patient is usually decided on the operation table. There is minor variation in the two procedures, but they address the same pathology. What was advised on 2nd of January 2019 was only corrected on 15th May 2019. Because the Honorable Court has directed me to obtain the certificate, I have filed the opinion of a heart surgeon. The Honorable Single Judge has allowed the claim of the petitioner.
So what is his claim? Some 2 lakh something. What is that?
2,83,000.
Why should we interfere, sir? Hardly any amount. This is not you're an insurance company, this is nothing. And it's a young boy. What is the age of the child?
Age of the child, minor boy, man.
So why are you fighting these kind of cases?
Because there was this policy was obtained.
It's a policy of 2014 onwards, sir. They have been having this policy.
No, this policy, my lords, is a special type of policy. This
anyway,
is
from 2014 onwards.
The proposal was submitted. This policy, my lords, heart medical policy is a special type of policy. And it was only issued in the year 2019, my lords, with effect from 30th January.
Whatever, sir. The boy underwent a checkup in that Rabindranath Tagore International Institute of Cardiac Sciences. The challenge in the present writ appeal is to an order dated 5th September 2022, passed by the learned single judge, allowing disposing of writ petition civil 22608 of 2020 filed by the respondent, which in turn questioned an order dated 29 January 2022, passed by the insurance ombudsman, rejecting the reimbursement claim made by the respondent for the single quote Rasteli repair procedure, unquote. No, for the heart surgery undergone by the son of the respondent, which according to them was covered by the insurance policy issued by the present appellate. Paragraph. One of the pleas urged by the appellant insurance company to resist the claim was that the insured had suppressed the advice given by the NH Ravindranath Tagore International Institute of Cardiac Sciences about the insured having to undergo a single course Rasteli repair, unquote, procedure. Full stop. It may be mentioned here that the insured is the minor son of the respondent. Full stop. The learned single judge noted the email dated 5th March 2019 that emanated from the appellant insurance company, admitting that, open quotation, customer has disclosed history of ASD/VSD surgery in 2014. Declaration was noted and considered. Full stop. No change in policy T&Cs, unquote. Paragraph. The other plea taken by the insurance company was that the actual operation undergone by the respondent's son was not single quote Rasteli repair procedure, unquote. Full stop. Nevertheless, the insurance company's expert opinion available to the insurance company confirmed that the operation that was undergone by the respondent's son was to address, open quotation, the same pathology as would be addressed by the Rasteli repair procedure, unquote. Therefore, there was no merit even in this contention of the insurance company. Paragraph. The impugned order of the learned single judge discusses all the above issues in some detail to arrive at the conclusion that the respondent claimant was entitled to reimbursement of the hospital expenses in the sum of rupees 283,438 as against the claimed compensation amount of rupees 3 lakhs. Full stop. It has been awarded with 6% simple interest from the date of filing of the writ petition, that is 7 September 2020, as well as costs of rupees 10,000. Paragraph. Having heard learned counsel to the appellant insurance company and having examined the documents and record, including the judgment of the learned single judge, the court is unable to find any legal infirmity in the impugned judgment that calls for interference. Full stop. As pointed out by the learned single judge, factually, the insurance company was unable to demonstrate that there had been any suppression of material facts by the insured that would go to vitiate the claim. Full stop. Moreover, the actual operation undergone by the minor son of respondent claimant was to address the same problem as would be addressed by the single court's Rasteli repair procedure, unquote. So in other words, there was no justification for the appellant insurance company to refute the claim in the present case. Paragraph. For the aforementioned reasons, the court finds no grounds made out for interference. The appeal is dismissed. Contempt, you say, now placed before the roster bench of the learned single judge on March 13th.
Item number 40.
I have been instructed to appear on behalf of the opposing party.
All right, sir. Is this a first day?
Yes, my this is the first day, and you'll also see the page 17, the impugned
So, Mr. Mishra, we've been passing those standard orders,
also
sending it back to the single judge. Sir.
Right, ma'am.
All right.
So that you'll also in that case you should notice, and if you'll
He's appearing, not this. Where are the other orders, sir? We're sending it back.
That
you don't have it.
No, madam. That in respect of rehabilitation assistance scheme, you'll also be fixing to 9th March.
This is rehabilitation assistance.
Yes, ma'am.
So you'll also be fixing to
Molananda Sethi judgment we rely upon.
I know.
9th March.
Considering that the issue the question whether the case of the question whether the claim for rehabilitation assistance should be considered in terms of the policy / scheme as of the date of the death of the government servant or the date of considering the application of the dependent is pending before a larger bench of the Supreme Court of India. Stop. That is the matter. List this appeal. When? What is the date?
It is 9th March.
9th March. Along with writ appeal number 1128
yes,
of 2022.
1128.
All right.
That means state one contempt petition is filed.
When
contempt petition has been filed.
Mr. Mishra states appearing for the senior counsel appearing for the respondent states that he will seek adjournment in the contempt petition in view of the pendency of the present writ.
Item 41.
May please, your order. The Honorable Single Judge has, though it was observed in para 6 that no writ petition is liable against private financer. In view of that, if your lordship found para 6 of the order dated 13/10/2022 at page 47, your lordship, it is stated that the writ petition against private finance company is not maintainable in view of ratio decided in Federal Bank Limited versus Sagar Thomas and others.
Correct.
Thereafter directed, your lordship, another point is that the guideline of RBI, which was quoted in para 5, but the order was passed contrary to that guideline, my lord. If your lordship peruse para 5, it is stated in the guideline, it is stated that it is clarified that loan account classified as NPA may be upgraded.
All right, sir. Notice till the next date of hearing, the impugned order shall remain state, or the learned single judge shall remain state. 11th May. Sir.
The order may be stated.
Item 42.
Item 42, it's a cover matter of your lordship, the ASO matter. Narottama Rao. Only difference is I have challenged the order of the appellate tribunal sub-collector, which has confirmed the order of the ASO. So that is the order.
The original order.
That's the order impugned.
The original order. You will produce the last paragraph.
Yes. Page number 17. May permitted to get the certified copy of the impugn order by substituting a Xerox copy after disposal of the case.
Which
over certified copy impugn order.
You can apply for the certificate copy.
Yes. Item 43.
It's a public interest litigation, my lord. A public pond over an area of acre 1.077 has been made to unused by dumping of concrete.
Yeah, we passed a long order, sir. On 4th January, we passed a long order.
My lord, this order has been communicated. The collector, I have yet to get some instruction. Last chance.
Photographs are to be produced
Yes,
today.
yes, all these things. Last chance may be given to.
Despite specific directions requiring photographs showing removal of the waste on the plots. Be produced before this court, Mr. B.K. Manthi, learned counsel appearing opposite parties, seeks more time. Post stop, it is made clear that if the compliance affidavit with photographs in terms of the order date 4 January 2023 is not placed on record on or before 31st March 2023, the Tahsildar Sorada will remain present in virtual mode on the next date. A copy of this order be sent forthwith by the registry to the Tahsildar Sorada. List on 6th April.
5th April.
6th.
Item number 44.
My lord, may I request to, may I know that whether the earlier order was served on the Tahsildar, because that order by the registry.
So we are supposed to, you have a portal.
No, by registry.
The whole idea of the portal is that all your officers get it immediately the same day. That's the idea of the portal.
Yes. This time I will ensure.
No, we have said copy will be communicated. It's been communicated. Yeah, it was communicated.
Yes.
4th January, communicated 16th. 4th week, he said. So you ask for an explanation. I won't put it through order. Ask for an explanation. What is the meaning of 4th week? There's no meaning. You have to make all the orders, you have to say 4th week.
Item 44.
May I please, my lords? This present petitioner, my lord, a purely service contract, my lord, is now interpreted by the assessing officer as a works contract, my lord. And here your lordship would appreciate the petitioner was engaged in raising of iron ore mines with the miner, my lord, KJS Aluwalia. And the scope of work was raising, sizing, screening, stacking of iron ore, and also a removal of overburden. Your lordship would get it at page 50, my lord, of the
No counter filed.
No counter has been filed. And your lordship would kindly turn to page 53.
It's all right. For the past 6 years, no counter affidavit has been filed. Last
your lordship, counter may not be required, your lordship. Your lordship, what happened?
May I just complete?
Page 53, your lordship may kindly turn to page 53. With great respect to my lord and senior, your lordship, the last 4 lines. As the transaction is under purview of transfer right to use, which is so and so, for the year 2013-14,
as per the period 9-10 to 12-13 has been dealt in the assessment order by number so and so 43. Now, Your Lordship may kindly turn to page 19 of the read petition, Your Lordship. So far as this 9-10 to 2012-13, the petitioners filed a read petition before this Honorable Court. And this Honorable Court has disposed of that read petition, Your Lordship, by directing to avail the alternative remedy of appeal, Your Lordship, on the same issue.
Your Lordship would appreciate, my lords, transfer of right to use, my lord, in a single word cannot be demonstrated without sufficient inquiry, my lords. There has to be a deep and pervasive control. No, but Lord,
appeal has been filed.
Not true, my lord, but Your Lordship would appreciate, my lord, the entire, Your Lordship, kindly turn to page 53, my lord, how he deals with the matter, my lords. For a moment, my lord, Your Lordship, kindly come to page 53. I'll just page 53 of the brief, my lords.
But why should we
do? Lord, he says, but on the face of it, my lord, Your Lordship would be satisfied, my lord, there's been no transfer of right to use, my lord.
But for 9-10 to whatever, 13-14.
Well, Lord, I bow down, Lord. I bow down, Lord, but the situations may be different, Lord, but here Your Lordship would appreciate.
He's followed that, in this order, he has followed that order.
No, Lord, he has not. He just says, my lord, what has happened, my lord, this assessment year for the 43 assessment year, a longer period was taken, my lords. For 42, my lord, there was an overlapping period. That's why, my lord, he has segregated 13-14 and has restricted the 42 assessment to 13-14. So what he does for this assessment year in 13-14, my lord, is the entire basis, my lord, is that I have transferred the right to use of my machinery to AGS Ahluwalia, my lords, which is not a fact. And, my lord, Your Lordship, kindly turn to page 53, my lords. All that he has done, my lord, he has only deleted that portion covered under 43, and for 42 purposes, he has restricted it to 13-14. Your Lordship, may kindly turn to page 53, my lords.
Yes.
The dealer SSE has received higher charges for an amount on behalf of deploying machineries at Nuagaon Iron Ore Mines of KGS Ahluwalia, which comes under the purview of transfer of right to use as per the terms and conditions of the work order issued to the dealer by Mrs. KGS Ahluwalia. And then, my lord, Your Lordship would come to the order, my lord, which is at page 23, my lords. The work order, my lords. May I just please that work order, my lord. Yes. The work order, my lord, is raising, sizing, screening, and stacking of iron ore in Nuagaon Iron Ore Mines. In addition to that, my lords, I was also given the additional burden, my lord, at clause number 5 for shifting of the overburden, my lord, and for transportation purposes. I use my own vehicles, my own machinery as a raising contractor, my lord, and my own vehicles, my lord. And that, my lord, cannot be construed to be a transfer of a right to use of my machineries, which I've been using for my contract work awarded to by Ahluwalia, my lords, to Ahluwalia, my lord, and then, my lord, the higher charges.
There's an interim order, we'll make it time bound and we'll continue. The interim order will continue.
But Your Lordship would appreciate, my lord, out of nothing, my lord, he raises a demand of 1 crore somewhat, my lords. With penalty, my lords. 1 crore, my lord, for nothing, my lords, without an iota of evidence that there has been a transfer of right to use, my lords. And as Your Lordship knows, my lord, transfer of right to use, my lord, in a single sentence, my lord, cannot subserve the purpose, my lord. So, and Your Lordship to appreciate, my lord, I've been paying at page 34 onwards as mining services. I've been paying service tax, my lords. At page 34, Your Lordship would appreciate. The entire, my lord, the transaction, whatever I do in the mining area, my lord, including shifting of overburden, my lord, was included as mining services, and I paid service tax on that, my lords.
It is 42 assessment.
No, what is 42 assessment?
Audit visit, Your Lordship.
But audit visit, they don't go and see, Lord, whether there has been a deep and pervasive
service tax he has paid.
Your
So mutually exclusive.
Your Lordship, it is to be all our factual concern. Your Lordship, it is the since audit visit report has been made, audit assessment has been made.
That case, if service tax is imposed, VAT you cannot.
Your Lordship, verify the entire issue.
Or you file a counter.
Let him file a counter.
Confirming whether it has been, VAT has been, service tax has been paid.
As Your Lordship, please.
You say one of the contentions.
One thing, Your Lordship, since for the other periods are pending for the appeal.
No, it's okay, sir.
Your
Is that in relation to the same transactions, which are sought to be made subject to value-added tax, service tax has already been paid. Paragraph, the court finds that there is no reply filed in the present petition, although notice was issued way back on
4/10/2016.
October 2016. Paragraph. Last opportunity is granted to the state to file its reply within 8 weeks, rejoined for the next date. Interim order to continue. List on 8 August.
Grateful.
Right.
Item 45.
So,
Let's, Lord, item 45 and 46, I'm extremely sorry to say, sir, that Justice Raman may not hear this matter.
Oh, I see.
Lordship, these two cases, counter agenda, everything has been filed. So a final date may be fixed for final hearing of the
list before a bench of which Justice Raman is not a member. 16th August. Right.
Interim order to continue.
Interim order.
Item 47.
47 not pressed.
Not pressed. Dismissed.
Item 48.
My lord, on behalf of Mr. Kausiguru, liberty may be granted to file appeal, my lord.
All right. Counsel petitioner to withdraw the present petition. Liberty to file an appeal is provided in law. Such appeal is filed not later than 10th April. Accompanied by an application for condition of delay, then it will be considered in accordance with law by the appellate authority. If it is accompanied by an application for condition of delay, application to stay, then till such time orders are passed thereon. The interim order passed by court on 22nd December 2017 will continue. The deposit already made by the petitioner will be accounted for at the time of final orders being passed by the appellate authority. The court clarifies it has not expressed any view in the matter. The petition is disposed of as withdrawn, liberty is paid for in the above terms.
Item 49.
My lord, item 49 has become infructuous.
Infructuous dismissed.
Item number 50.
50 also not pressed.
Not pressed, dismissed.
51.
51, my lord, here I have challenged the demand notice. The demand has been raised on the ground of there is a public objection, which has been not admitted by the OP number, the opposite parties in their counter affidavit at para 6. That due to public objection, the shop was closed and there is a lot of ladies were that para
So there's a standard order that we passed, right?
Standard order.
Lordship may.
Where is that?
Lord, I don't have the, today I'm out. No. Lordship direct. I will approach the commissioner and I will cite the decision of this own court. Where
Yes, that can be, that is
that
fair enough.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the court, commissioner, excise commissioner, to consider the plea for waiver of the
MGQ and license fee, both. Because it is license, it's not issued.
as well as license fee.
Yes.
If such petition is application. Application is filed not later than 17th April 2023. Then after hearing the petitioner, a reasoned order shall be passed thereon by the excise commissioner within 3 months thereafter.
No, I will cite the decision, well, that may be considered.
Whatever, sir. It will be open to the petitioner to raise all pleas available to the petitioner in accordance with law before the commission. The petition is disposed of. The court clarifies it is not expressed to me in the matter.
Item 52.
My lord, in this case, the petitioner is a license holder of a observe, my lord. Here, the petitioner has challenged the demand notice issued on the basis of the AG audit report made for the year 1918, my lord. Although the excise duty for the year 16 and 17 was
there is a standard order.
And that has been adjusted, my lord, against the short lifting of a beer.
Same order which we passed earlier.
AG audit.
AG audit.
This is only for waiver of MGQ, is it?
AG audit that has been adjusted by lifting of excess quantity of IM plow.
No. Do you have the order passed in similar matters or?
There has been an interim order, my lord. It is of demand notice has been.
Have you got that standard order?
No, my lord.
That is with Mr. Patra. Mr. Rotha is also there. AG audit.
Point the government treating this and to give notice with the interim order.
This copy of the order, if you give it to, we'll pass it over, just find out. Pass
The
it.
order ta de dena.
I'll supply a copy.
All right, pass over. All right.
I'm sorry, my lord. But item 51 interim order passed by this one court will continue. Dated 22nd 3/2018.
All right, till such time the interim order to continue. All right.
Obliged.
Item 53.
Your Lordship, I am on behalf of Mr. Acharya, Lordship. Mr. Acharya is in a personal difficulty today. Your Lordship may call this matter on any convenient day. Meanwhile, we'll also file a rejoinder, Your Lordship.
Case has not been admitted.
No, notice has gone, sir. Acharya has been some personal difficulty today. List on 16th August. Interim order to continue. Rejoinder be filed for the next.
Oblige, Your Lordship.
Item number 54.
Lord, item 54, there are 4 matters. Lord, out of all, my lord, I'll request your lordship to take up the second one, which will be a lead matter.
Right.
In the second matter, before I take
17719.
This is no 16247 of 2021. Here the counter rejoinder and everything are there. Now, there is a noting by the office with regard to requisites, but then the date when the notice was issued, the Dropbox system was there. So we have taken notice through to the OP number 5 by ourselves, giving a copy of the petition by registered post. We have filed a memo to that effect. If that is treated as sufficient,
but is anyone appearing?
Flag B, no? Flag B, capital B. No, nobody is appearing.
You don't know if they got it. Who has filed counter? State has filed.
State has filed counter, but we have also filed rejoinder. Otherwise,
may I submit one thing? This is relating to when the lottery was conducted, in certain places, we have extended the time period. And during that extension period, some applications were received and they were considered, and the SOP has been allotted. 2 years they are running. Now they are challenging that extension. So they already 2.5 years complete, 2 years completed. And now it cannot be reopened according to my responsible submission. They are already settled, all the SOPs. So this is become more or less infructuous.
Now, what's the total period of extension?
No. 7 days extension for acceptance of
acceptance.
That is for that extension.
No, whether it's a 5-year.
All are finally, my law plan will also agree to it. All are finally settled in favor of different lottery owners.
No, but for how, there's a period, right? 5 years.
That is a period. No. That period has not. Let us, for example, if we have fixed the date till 31st March for application, it is extended to first week of April.
Correct. No, but when you grant the license,
already granted.
It's for a period of 5 years.
That is for 5 years. They are already.
So of those 5 years, they've crossed 2.5.
Crossed already 2 years.
But in fact, Mr. Mahanti will little appreciate it. The way we filed it 2021, there is an interim protection that all these actions shall be subject to result of the request. That is one. Two, my lord. But the point here is immediately we have approached your lordship, and your lordship, that's the reason protected us in the licenses who are being considered, said that it shall be subject to result of the petition. Now the point here is whether the commissioner of excise within 4 corners of that e-lottery policy has the power to extend the date at all or not. The power vests with the collector, not with the commissioner. Now commissioner in respect of 17 districts extended the date, and in respect of those districts, selected people are those within the extended date they submitted their application and got selected. That's the point. If commissioner has no power of extension, the whole basis goes. So they have to conduct a fresh lottery. That's the reason we are pressing the matter.
What do they say in their counter?
They say in their counter, I'll just request your lordship to see those 2 provisions.
1 week, I think, 1 week extension.
No, page 12, your lordship, make kindness. No. That is the provision with regard to extension of date, page 17. That's the power. Kindly see,
17 of the?
Of my writ petition.
No. In the counter, what do they say?
In the counter, they are saying the commissioner has the power to extend, the commissioner has the power to adjudicate disputes regarding lottery, and that's the power in exercise of which commissioner has rightly extended the date. That is what they are trying. That's in my humble opinion, my lord, Nazir Ahmad and everything will come into play. My lord, I think provided to be done in a particular manner, should be done in that manner only. Those two clauses I'll cite your lordship, lord and lordship, see whether the commissioner can derive power of extending the date from
And
that.
what is the cause? Because of technical issues, internet problem in some.
Who should?
Yes, that is commissioner has the power. That is our assertion in our counter affidavit, because commissioner is the authority who was conducting the lottery, and all excise superintendents and collectors are under the commissioner. And that is what we have stated in the counter affidavit, that the commissioner is the authorized person under the law, and he has extended only 3 days or 4 days, something like that. For
where is the provision? Let's see.
Kindly see, lord. Page 25.
25.
25, 17 and 25, both same provision. Running page 17, internal page 7. If no application, lordship's got it, but
page 25.
With page 17 will do.
72.
17, 17, my lord. Roman 14. D, small d.
1 minute. You're in the second matter.
Is second matter, my lord.
16247.
My lord, this is 162, great, my lord. 16247.
But page 17, 17 is something else.
117, 17 of the
16.
17.
Roman small 16 it starts. 17.
The lottery shall be held subject to following.
If, yes, small, it is small, Roman 16, the lottery shall be held subject to following conditions.
Correct.
Namely, D, my lord, small d. If no application is received, on the scheduled date, the collector may extend the last date for filing of application. And if the last date for filing of application or the date fixed for trial of lottery is declared by the government as a holiday for any reason, for any special reason, or for any unavoidable contingency, the collector shall reserve the right to defer the date to some other suitable date by issuing a public notice to that effect. Let's may kindly see the contingencies here. But besides the holiday or special reason, any other ground, Milord, for any unavoidable contingency, that includes the technical issue, technical snag, whatever it comes out with. Now, it is the exclusive power of the collector appreciating the ground reality in respect of the district to extend the date. Now, Milord, let's see the commissioners, Milord, that sought to be used in saying that commissioner has the power. Kindly see page 14, Milord. Roman 17. Decision of the excise commissioner. Decision of the excise commissioner relating to any dispute on account of lottery in the district shall be final and binding upon all applicants to the lottery. But here the question of a dispute doesn't cover the field, which the collector has under Roman D, 16D. So besides that, if Lordship appreciates one more point, as on the date of application, if there is a single application, there is also a provision for that, what is to be done. He will be declared as a provisional lottery winner. But that right is there in favor of the applicant, and one case is also there. In case of one of the petitioner, he was single applicant. But yesterday it was there. But because of this extension, now he is deprived of that. Page 12, my lord. Page 12, Roman 7. On the day assigned for lottery, collectors shall draw the lottery in presence of the applicants or their authorized agents. In case there is only one application for a shop, collectors shall declare the name of the applicant to be the provisional winner of the lottery. So single applicant has also a right here. So in view of this, my lord, if your lordship kindly see that commissioner passes an order, annexure 1, kindly see, my lord. 30th of March 2021, page 10.
Yes.
In view of receipt of huge number of complaints from the intending applicants regarding poor response of server and technical issues as to number of applicants would not be able to submit the application within the prescribed time limit, the last date for submission of application to participate lottery in 15 excise districts, Barampur, Katak, Bhadrak, Baudh, Dhenkanal, Ganjam, Jaspur, Jharsuguda, Kalahandi, Kendrapada, Keonjhar, Koraput, Mayurbhanj, Sundargarh, Noaigad, Sambalpur, which was on 30th of March 2021, is required to extend the last date up to 31st of March. 31st of March, 5 p.m. In respect of 2 excise districts, Baleswar and Khurda, last date of submission application is 1/4/2021. Now, my lord, it did not stop here. If lordship sees their counter A by 1, the commissioner again extended it by another date. Running page 56, madam.
Yes.
In partial modification of letter number. Lordship, what it was?
Yes, yes.
Letter number 2118 dated 30th of March 2021, in view of receipt of huge number of complaints from intending applicants regarding poor response of server and technical issues, as are the number of applicants could not be able to submit the application within prescribed time limit. The last date for submission of application to participate in lottery 15 districts, Barampur, Bhadrak, Baud, Dhekara, all the same districts, which are on 30th of March 2021, 5 p.m., is required to extend the last date up to 1st of April 2021, 5 p.m. But same, in verbatim, same words reproduced again, whether in fact that was there. What is the report of the respective collectors, my lord, in respect of these allegations? That was not there. Nothing is available on record, and commissioner has been passing orders after order, extending the dates. Now, if lordship sees one more letter from counter, page 60, running page 60.
Counter?
Yes.
Counter page 60.
Running page 60, internal page 13. Now, the Superintendent of Excise Harsuda here writes, in portions of letter in memo number 2122 dated 30th of March 2021, the Excise Commissioner of Odisha, District Magistrate and Collector Khurda has been pleased to extend 2 more dates from 30th of March 2021, 4:25 p.m. for submission of application of settlement supplement financial year 2021 through online. Now, there is no letter, there is no number, there is nothing where the District Magistrate has passed the order. Superintendent of Excise is passing this order. Now, nothing is there. No reference.
Yes, Mr. Monk.
Yes, my lord. Lordship may kindly have a glance. Para 6 of the counter affidavit.
Yes.
The reasoning assigned in the impugned order annex, it is only for 24 hours we have extended in some stations due to this, the reasoning we have assigned. Now the authority given to Excise Commissioner in SRO of this, that the amendments made in so and so, not it is humbly submitted that SRO number 61 of 20 and para 14, it has been made clear that the decision of the Excise Commissioner Odisha relating to any dispute on account of lottery in the district shall be final and binding upon all the applicants to the lottery. Copy of the extract so and so is annexed.
No, that's very different from saying he can actually extend the time.
No, this is a dispute because many the objections were received by the Excise Commissioner. A dispute arose between before the Commissioner, so he adjudicated the same and only extended for 24 hours. Your Lordship may kindly imagine.
No. It's not about only, sir. Can he not is the question.
Yes, that is there. But the reasoning which the Commissioner has assigned in the impugned order, that comes under the definition of a dispute in terms of this para 14 of the 16 of the.
But that's not even the issue, sir. The issue is not whether it is a dispute or not. The issue is, can he extend the time?
Sir, because of that, to address that issue, the Commissioner has passed this order for the betterment of. And another thing, how the petitioner is prejudiced. If it is extended, he is also eligible to participate in the lottery. So, and all the things are after 2 years, can it be reopened? Your Lordship may kindly imagine. They are already been.
They came immediately, sir. The court, they came in 2021.
No, because they are, and I have given in my counter, they have also participated.
Respond number 5.
Beg pardon.
Again, same issue. What happens to respond number 5? Opposite party 5.
Lord, in fact, we have given to registered post from our office.
Don't want to, because that was.
That if doesn't solve the purpose, then I'll have to take out a fresh notice.
Fresh notice to opposite party number 5. Returnable on.
In all the cases.
No, in all the cases. Lord, an early date, Lord, because 5-year period, again 3 years will go, my Mr. Manthi will say that.
I think maximum opposite parties are the clients of my learned friend who are enjoying this license for last 2 years. So after 2 years, why you are?
That is the nicety of this profession, my Lord. We change our colors.
6th July, sir.
July.
My Lord, 6th July.
Which one? In the last case, he says OP5 is appearing.
He was appearing.
Sanmukha Patra.
Yes, my Lord. In the other case, they were appearing, but this second matter process is not over.
So except 17719, the others. And 1719, you just list on same date, 6 July.
Item 55.
My lord, this petitioner has died only recently out of cancer. So 11th of February he has died, my lord.
So awaited.
It's a question of payment of money, so I'll have to take
Alright.
steps.
It is the court is informed that the petitioner is expired. And that his LRs have to be brought on record. List on 13 July.
Yes. 56 I'll withdraw, man.
Disposed as withdrawn.
The rest of these matters with regard to relaxation of
57
COVID, MGQ and license fee for because of the COVID. Now, COVID for state lockdown, whatever lockdown was declared by the state, the government has been pleased enough to waive the. But here the contingency is that there was localized shutdowns by the collector under the order of the government. Those sporadic periods, the government has not been considered because once you have exempted for statewide lockdown, these were also lockdown. So humbly I'll pray that you may permit me to raise this issue before the government. Let the government take a call and take a decision.
All right. In all these petitions, counsel for the petitioners seek leave to withdraw the petition with liberty to approach the government
56
with appropriate representations.
56.
If such representations are made not later than 17th April, then after hearing the petition on a date to be informed to the petitioner at least 10 days in advance, a reasoned order shall be passed thereon by the government within a period of 4 months thereafter.
57 to 63. But this is from 57 to 63, all these are disposed of with the same order passed.
Right.
And 66 sub-item. And 66 also sub-item. Lord. The first matter is not mine. 66, the sub-item. 8071 is same matter.
Yeah.
Grateful.
Milord's item 64 to 69 is similar with Mr. Author's. A similar order may be passed.
All right. In all the other matters also. Up to 69, is it?
69, Milord.
Right.
Except sub-item of 66, Milord.
Right. 66 will be first sub-item. Right.
Item number 70.
None appears dismissed. Both matters.
Item 71.
I praise the Lord. But the matter is that, Your Lordship, kindly will come to page 41. But here the background of the case is that the petitioner is an industrial consumer and he was drawing the power by virtue of an agreement. My lord, the meter was replaced on 20th October 17. My lord, he was regularly paying the bill.
You're for the electricity company?
My lord. And my lord, on 12/1/2018, there was an inspection. And after that, but though up to November, all payments has been cleared, there is no allegation of non-payment or anything. Then in December, that bill was immediately raised, 20 lakh something. So that is why, my lord, he made a complaint and the executive engineer said, you deposit 5 lakhs, they get connection. Then that moment, he went to the GRF. And the GRF, after GRF, then GRF held that our contention is that regulation 97 and 98 applies. Because if there will be any defect or anything is there, then it should be calculated preceding average billing of 3 months. Then on that basis, so far the domestic and agricultural consumer are there, for 3 months billing that will be done. Otherwise, for other consumers for 6 months, but the average of the 3 months. That calculation they have not given also. That was one of the claim that you give the calculation in what basis you are doing this thing. Then both the forums as well as the Honorable Single Judge held that it is a escape billing and there is a clerical mistake and 97, 98 does not apply. Well, this is totally without any basis. That must be by virtue of a law. That does not permit anything anywhere under the OERC code that there will be any clerical. That must be codified under the provision. So in this, at this juncture, may I draw your lordship's attention to admitted fact that is recorded in the finding, page 41. Lordship, kindly just come to the last persons. It is admitted case of the petitioner that initially power supply was made on 30/8/2016 through 3 PS 4W5 5 AM 11 kV 110 VMU. Subsequently, as per letter number so and so, the existing 3 PS 4W 5 AM 11 kV was replaced by so and so MU, keeping all other metering arrangement as it is condition. As a result, after replacement of a upgraded metering unit, the multiplying factor changed from MF100 to
No,
MF4.
under the order of the single judge.
Yes, my lord. Then finding, my lord, and the finding your lordship will find that finding is page 45. Page 45.
So the demand was 20,36,000.
Yes, my lord. That is absolutely without any basis. Because if your lordship will find the provisions of law that is recorded, that is page 44. Billing with a defect meter. For the period the meter remained defective or was lost, the billing shall be done on the basis of average meter reading for the consecutive 3 billing periods succeeding the billing period in which the defect or loss was noticed. It shall be presumed that use of electricity through a defective meter was continuing for a period of 3 months immediately preceding the date of inspection of in case of domestic and agricultural consumers, and for a period of 6 months immediately preceding the date of inspection for all other categories of consumers, unless the onus is reverted by the person, occupier or possessor of such premises or place. If the readings of meter working in association with current transformer CT and potential transformer PT and other auxiliary equipment, if any, are found to be incorrect or account of wrong connection or disconnection of such CT, PTS and other equipment, or on account of omission or commission in regard to multiplying factor, erroneous adoption of CT ratio, PT ratio, the billing in such cases shall be done as laid down in Regulation 97. So, but keeping in view, my humble submission, lordship, kindly see the findings, page 45. My lord, the last paragraph. The lordship, kindly see. The condition laid down under Regulation 98 is regarding reading of meter with current transformer and potential transformer, which found to be incorrect, and applicability of the provisions of Regulation 97 will come when it is a case of defective meter, as has been stated herein above, that it is not a case of defective meter. It is also not a case of reading of the meter found to be incorrect on account of wrong connection or disconnection of current transformer and potential transformer or other equipment, and it is also not a case of any omission and commission in regard to multiplying factor, rather is a case of replacement of upgraded metering unit by virtue of which the multiplying factor change, so on, so on. My lord, in this, at this point, my humble submission is that, my lord, here abruptly the conclusion is there without any supporting provisions of law. There was a clerical mistake, or there was because of upgrading metering. But meter was also not defective. Whatever meter was going on, for that meter, whatever the billing was made, we have made the payment regularly and clear up the amount. Then after 20th October 2018, the meter was replaced. Thereafter, we have paid the regular payment. But all of a sudden, this amount has been raised, but it is not supported by any provisions of law. If it would have been omission or commission or any defective meter or anything else, then it would have been billed under as per 97 or 98. So that is why, my lord, the calculation as per what provisions of law, that is not known to us. So that is why it has been affirmed by both the forums as well as by the Honorable Single Judge without any supporting findings in the support of that. So that is my submission, my lord. And in this regard, there has been no consideration by the Lord and Single Judge. So, my lord, it requires a reconsideration, or your lordship may consider the matter.
Yes, please.
My lord, my submission to your lordship is the entire contention of my learned friend that regulation 97 and 96 and the honorable single judge 97 and 98. Therefore, the honorable single judge in page 44 has categorically explained what is 97 and what is 98 and come to a conclusion, both the forum below, that it is an escaping, because this bill has been raised because it escapes when it is raised from 100 kilowatt to 400 kilowatt. That 300 kilowatt has not been calculated during the billing period. What he has said, that I have cleared the dues. He has cleared dues up to 100 kilowatt, my lord. So for the 300, what is enhanced, that accept has not been billing in the billing provision. Therefore, if they escape the notice, when it comes to the notice, that bill was raised. Therefore, there is nothing wrong, and 97 and 98 not applicable so far the petitioner's case is concerned. Neither it is defective meter. It does not come under the 97 or 98. Therefore, my submission for lordship is the judgment passed by the honorable single judge is justified. And
is there a calculation sheet for the bill?
Nothing has been given. Your lordship will find what my learned friend says, that is contradicted by the provision, because the escape billing is coming within the purview of regulation 98. What he is submitting, that must be supported by some regulation. What provisions are not. But you can't do this in an arbitrary manner. And the honorable single judge has also come to arrive at the findings that it is neither commission nor defective meter, all these things. So that must come within the purview of any provision, so that it gives power to you to do this thing. So that is, my lord, if something has been provided to be done in a particular manner, you can't do this in the arbitrary manner. So that is, my lord, is a consumer, is a genuine consumer paying regularly the bill, but you all of a sudden you raise the bill and without giving the reasons. So that is, my lord, the grievance of the petitioner. Or else, lordship may direct for fresh consideration of the matter. All these aspects have not been considered.
Yes.
May I place that from 43? The last paragraph 4, subparagraph. It is further contention of the petitioner that the grievance redressal forum or the ombudsman have given finding regarding non-applicability of the provisions of regulation 98. This is also the contention before the GRF as well as the
yes, that I am repeating the
of the OERC Code 2004. Thus, this court has gathered from the argument advanced on behalf of the learned counsel for the petitioner that he is not disputing the replacement of upgrading meter unit from MF 100 to MF 400. It is also not been disputed. The testing of the metering unit, it is also not disputed. Not been disputed. The change of multiplying factor so as to the clerical mistake. Rather, the only contention raised that even accepting all these things, the bill is to be calculated only for the period of 3 months immediately preceding the date of inspection as per the provisions made under the provisions of regulation 97. Therefore, 97 is not applicable because 97 is applicable only on the question of defective meter. The court, in order to appreciate the argument advanced on behalf of the learned counsel for the petitioner, has taken into consideration the provision of regulations 97 and 98 of the code, OERC Code 2004, which are being reproduced herein below for better appreciation. For the period of meter remained defective or was lost, the billing shall be done on the basis of average meter reading for the consecutive 3 billing periods succeeding the billing period in which the defect or loss was noticed. It shall be presumed that use of electricity through defective meter was continuing for a period of 3 months immediately preceding the date of inspection in case of domestic and agricultural consumer, and for a period of 6 months immediately preceding.
That I've read already.
Yes, yes.
I've placed
I'm repeating that. That is the crux of the case. Inspection for all other categories of consumers, unlike the owners, is rebutted by the person, occupier or possessor of such premises or place. Therefore, my lord, the argument advanced by my learned friend that it should be calculated for 3 months, it is not applicable because his meter is not a defective meter or it was lost. It is the only calculated because it is for enhanced unit. As per his request, it was enhanced from 100 to 400. But
no.
Yes. That's your contention before the
one of the contentions is that you have not shown the calculation.
Calculation,
on what basis you have calculated the bill? That's one of the contentions he's raising. Correct?
My lord. Yes, my lord.
That your calculations are not shown at all. On what basis is he supposed to know whether it's correct or not? If you say it's not defective meter,
he has not raised these points.
No, yes, it's definitely there.
My lord,
I'll tell you where. It's been noted by the single judge also.
My lord, I do not know whether it is before a lordship or not.
No.
The petition he has filed before the grievance redressal forum.
Where is that portion, sir, where you have disputed the calculation?
Yes. My lord, yes. Page 40.
40?
Yes.
That's what I thought.
Further case of the petitioner is that bereft of replacement of such meter, the opposite party regularly raised bill on every month and the same was being paid by the petitioner without any delay. On 12/1/18, the opposite parties have inspected the meter of the factory premises of the petitioner and raised bill amounting to so-and-so for the month of so-and-so.
So do you have this
without any supporting documents?
Do you have this calculation sheet, sir, in your record?
I have not. Your lordship may grant me some time, I will produce.
All right. So one of the contentions raised by the appellant is that for the bill of rupees 20,36,380 raised against the appellant for the month of December 2017, there was neither any supporting document nor calculation sheet. Full stop. It appears that the learned single judge did not insist on the respondent producing such supporting document or calculation sheet paragraph. Since this is one of the key area, one of the principal contentions, of the appellant, the court considers it necessary to direct the respondent Isn't that now Sesu still there?
That is
Tata.
Your lordship, on my prayer, lordship, TPCODL.
So right in the beginning, you said the oral prayer of the council, the learned senior counsel, the appellate. Respondent 1 is replaced by Tata Power Orissa Distribution Company Limited.
Yes, ma'am.
Central Orissa.
Central Orissa Distribution Limited.
The address you'll have to give, sir. The amended consolidated cost title be filed within a week. Then you say this, whatever I dictated. An affidavit shall be filed by respondent 1 within 4 weeks, including the relevant documents which would show the basis for calculation of the aforementioned bill amount.
Yes.
List on interim order to continue.
Yes.
List on 21st August. Not 21st August, 1 minute. 17th August. 17th August.
Item 72.
17th August.
In 72, Mr. Samir Class is appearing. I am appearing in 73. In 73, an order was passed by a coordinate bench. Let's look to that order. Order number 7 dated 16/11/2022. Yes. There is some development so that I can file an affidavit. In my case, order has been passed on 16/11/2022 by the division bench presided by Honorable Justice Singh.
Towards the order, sir. Oh, it's there in this.
Yes.
Item 73.
That item 73 in my case.
Right.
Of course, 72, I am not appearing. Mr.
No,
Das is appearing.
The lordship come to the impugn order.
What I suggest, Lordship, because of this order, I want to file an additional affidavit. So far the development of case is concerned.
Page 33, the impugn order. Lordship, turn to page 33. Like Lordship, the two read couples are there. Page read couple is.
Since Mr. Das is not there, I am not in a position also to argue that matter on behalf of Mr. Das. So I am in 73, I want some time.
Oh.
On behalf of Mr. Das,
Yes.
copy not serve. I copy not serve mine.
Both. I तो देना है किसी
State region.
State
appeal copy.
वो कॉपी ला कॉपी है अपील कॉपी से नहीं है
Yeah, yeah, you have appeared on that. You have taken.
I copy.
I the file.
कौन से में
File 169 of 2023.
नहीं ताने
You have appeared. State ପାଇଁ जो file କରୁଛନ୍ତି
Do you want time Mr. on behalf of Mr. Das or you want what 72 कौन तो total?
In 72, there are cross appeals.
There is another appeal by the state, one appeal by the municipality.
Two appeals are there.
Two appeals. He
One
says
by
that
municipality
in the
and
second
another by
appeal,
the
he has not
state.
been served a copy.
We stand on the same footing. Lordship, take my read appeal, the state read appeal, that is 607 of 2021.
Yes.
That order is at page 33.
33.
Well, now this is a case of transfer. Lordship, come to page 37, the operative person.
Deemed to be continuing in the municipality.
Yes, ma'am.
This has been stayed by this court in writ appeal.
Yes, ma'am. Yes, ma'am. They also have stayed this.
And they have joined now.
They, out of three applicants are there, two joined in the Hindu municipality, and one has not joined, and the second one, he has been compulsory retired from service, and because of that writ appeal is pending, that compulsory retirement has been stayed. Honorable single judge.
I want to take instruction in those matters because that
I have filed an affidavit in that second writ appeal, that is division.
You have not served me a copy at least. Please serve me a copy.
On 155 of 2022, and your lordship has stated that impugn order, thereafter he was involved in a criminal case and he was prematurely retired, and that has been stayed because that writ appeal is pending. And we have to obtain leave from my lords. That is the order. Your lordship may see my affidavit. That is the order passed by the Honorable Single Judge.
Please serve me a copy so that at least I will have a response then.
I am showing that order of the Honorable Single Judge.
In 155?
Yes, ma'am. Sorry, ma'am. In 73, say in item 73.
Writ appeal number 431 of 2021.
431 of 2021.
That is by municipality.
There you will see my the state's affidavit, madam. Last annexure, page annexure D by 2.
Yes.
Order of Honorable Single Judge. That compulsory retirement has been stayed because
this writ petition is still pending. This writ petition is pending.
Yes.
Oh.
Prospect, give me some time so that I can give my response to this miscarriage. Just now, my lieutenant submit. Just now.
Mr. Buddhadev Rautre appearing for the respondent. in WA 431 of 2021
431.
and 608 of 2021 wants to place on record certain, by way of an affidavit, certain developments that have taken place, is permitted to do so within 4 weeks with an advance copy to counsel for the other parties who are at liberty to respond to the said affidavit before the next date. Interim orders to continue.
Well, may I pray a short date maybe because that man is continuing by virtue of interim order. Your Lordship, your Lordship has
No,
seen
you
that.
have not been allowed to join. Also record my statement that you have not been allowed to join.
Compulsory retired, can I say allowed?
That's right, then there's nobody's going to get affected, sir.
Well,
13 July. So all these 72 and 73, is it?
Yes.
13 July. 74 is one large batch.
74.
74, you also have fixed all these matters to 27/3/2023. All connected matters.
All right. List on 27/3/2023.
Along with read appeal number 283 of 2022. 283.
Along with 283 of 2022.
Right.
WA 283 of 2022.
Item 75.
This is,
May I please, your lords?
you say the interim orders in these cases are made absolute during the pendency of the present writ appeals. All the IAs, corresponding IAs are disposed of. Yes.
May I please, item 75.
75.
Yes, please.
May I please, your lordship? The Honorable Single Judge has not considered the case of the present appellant regarding giving her promotion from the level 5 to level 4 from the date when one person, namely Kulamani Pradhan, was retired.
The last order, it says, produce your short time to
And
produce.
that is admitted by in the counter affidavit that they have given promotion. Your lordship, say kindly, the reply affidavit has been given by the opposite party number 5. That only their ground, your lordship, say kindly, page 5 of the reply affidavit, in the last page, why they have not given the promotion and the relevant pay, because they are the previous gradation list prepared by the DIF schools banking level was automatically lost its force from the date of reorganization, that is from 18/5/2013, Millard. That is, but in fact, the post was
this counter affidavit was filed on 20th October 2022.
Yes.
The order passed by this court was on 3rd November. After that.
This honorable court director, the persons who have been given promotion, that when it was approved by the concerned authority, that should be produced. But it is not disputed that they have not been given promotion. They have given promotion. That is admitted fact. The only question is to be considered, my lord. Your lordship, kindly see page 26, the selection committee. Page 26, the selection committee.
Read the 3rd November order. The 3rd November order passed by this court.
Madam.
Do you have that?
No, my lord.
We'll give it to you. It's our duty to give you your own case orders. Correct. We'll do that. We'll do that. Kindly read it, sir.
Lord and Counsel for the appellant prays for time to produce document to show the date of approval of the DPC, the date of vacancy which arose to be filled up from the promotional quota, and actual date of promotion of the petitioner from level V to level IV. List on 20 January 2023. That will the matter to that respect, Miller. I have not the document obtained in document. The husband of the petitioner applied under RTI Act, and the authority has given a reply. Lord, you kindly see that the office has not received any information from the concerned authority. After receipt of necessary information, further steps will be taken accordingly.
What is this? Have you seen this? What kind of reply is this?
When I reply to my
The only question is, Miller,
paragraph 5 of my counter.
All this information, is it available in paragraph 5 of your counter? You also don't have a copy of the court's order. Sir, you also don't have the copy of the court's order.
Last order. Last order 3/11/22. Yes, my appellant prays for time for produce documents to show the date of approval of the DPC.
Now you produce all of this. When he asks you, you give a vague reply.
No, he has taken time. Appellant has
Yes,
taken.
sir. He took time. He wrote to you. He wanted that information. Look what you have told him.
Yes.
This office has not received any information from the concerned authority. So you're just making him run around in circles. It's better you produce this information.
Well, I will take instruction.
You say, although on 3rd November 2022, the counsel for the appellant had informed this court that he will produce certain documents and information. When the appellant wrote to the
husband of the appellant.
When the husband of the appellant wrote to the department, concerned department, the information was not made available, stating that it has not been received from the concerned authority. Paragraph. In view of the above response, a direction is now issued to the SNME department to furnish to the court by way of an affidavit the information sought in the order dated 3rd November 2022. The affidavit be filed within 4 weeks. List on 4th July.
May I play one thing, Lord? Because the petitioner is going to be retired, appellant is going to be retired on the month of May 2023. So prior to that, your Lordship.
What difference would it make? Only the difference in pension and other things.
After that,
it's only
promotion you have got. Promotion already has been accorded to you.
No, my lord, later on, because I am praying from since 2013.
That's it, it's only about date. So it doesn't matter.
He has already been promoted to level 5.
That I don't dispute, my lord. That I don't do. They have given subsequently, but I am entitled from 2008.
That will decide. Yes.
Item 76.
In 76, your lordship, similar matters have been fixed to 27th March.
27th March.
77.
In 77, there is a noting that sole respondent numbers
expired and left.
That I'll take steps for substitution.
What is the matter about?
That is regarding that one is promotion during pendency of that criminal case. And your lordship, all the matters have been fixed to 27th March.
The respondent stated to have expired. Counsel of the appellant states that he will take steps to bring the LRs on record. When are these matters coming up?
27th March.
List on 27th March.
Item number 78.
Your Lordship, item number 78, Mr. Gautam Kumar Acharya is in bereavement. Kindly take the matter after 27th Feb.
There's an interim order. When are the connected matters coming up?
My lord,
this is different.
It's different. It's similar. No similar matter. That is completely different matter. The lordship has issued notice.
Notice, Mr. Who will accept on his behalf? He's a senior counsel, correct?
Yes.
Who's on his behalf? Who will accept? Which lawyer will accept?
Will you accept?
Yes.
Put down your name, sir.
Your name. Pravas Naik.
List on 4th July.
Item 79.
Leading case Malad is coming up on 14th of March.
All right, list on 14th March.
All the batch cases.
This is also a single day, same day disposal.
I know, but coming on.
Yes, 14th March.
Then we can pass the similar order that day.
Yes.
Said today you are there. Let's send it back.
Lord,
First day matters.
In the bid matter, the batch of matters is disposed of.
That's it. Today's order will pass on 14th March, similar order.
No, but 14th March is separate, that retable. This is just the single day, you'll also say page 39. On first day disposal.
First day disposal, sir.
Page 39. Page 39. Our case, page 39. Our case is not covered by that judgment and he has suppressed the matter. So we have not filed a counter on the single day disposal. No, it's not single day. It's a batch of matters are listed on that date. And it was agreed, it is agreed by the council for both parties.
That is.
So on that basis, a lot of disposal was there. And since 14th March, is all the matters are coming up. Issue is one.
No, but it's on the first day, sir. Although it is order number 4, but literally in the very first hearing.
No, it's order number 4. Thrice it was listed before. Thrice it was listed.
Listed, but not heard. This is the first date of hearing.
No, it was there. All the batch.
No counter was filed.
No counter was filed.
No counter was filed, sir.
No, their counter was filed. In that case? Yes. Counter reserved, everything is filed.
In all these matters?
Yes, brother.
Oh, I see. Okay, then what is this?
Because if one case was taken to be the leading case. Yes. And the last occasion, my lord, I have also filed 10 judgments of along which, my lord, you will also have judgment in the memo also.
No, this is the same vigilance case and being promoted during pendency of the vigilance case.
No, this is not that case.
I see. This is a regularization.
This is the case, my lord. They are
regularization.
Regularization. 79/2013 regulation.
No. So 19951.
Yes, but
what has happened in that case?
That is, my lord, listed, my lord, on 14th March.
All right. So list on 14th March. All right. Fine. All right. We'll continue after lunch.
Supplementary list item number 80.
May I please? Let me turn to page 36. My learned friend has also appeared. This is the first day disposal. Let me see page 36.
We'll check it back, sir.
I'm not filed counter without permit.
No need. Done before this in a single judge. You have a copy of the order now.
That yesterday's item 80 is same.
So why don't you keep a bunch of those orders?
Not uploaded, my lord.
Sir, we've never passed such an order here in any of your matters.
No, the similar matters, other matters are there.
If you want to adopt shortcuts, it's okay. Basically, you want to increase work for us.
Sorry.
Although we may have passed hundreds of orders, similar orders in your favor, you don't keep copies.
Sorry, my lord.
Thank you. Thank you very much.
Sorry, my lord.
Thank you very much.
Sorry, my lord.
You see, on the short ground that the impugned order was passed without affording an opportunity on the very first day, without affording an opportunity to the appellant state to file a para-wise reply to the writ petition. The impugned order is set aside and writ petition civil, so and so, is remitted to the first bench of the non-single judge, where it will be listed on 8th May. In fact, this is the only court where in state we pass some orders, they don't bother to keep copies. We pass orders in favor of petitioners, appellants, they don't keep copies.
Normally,
and orders passed in their own matters, nobody bothers to even apply for a certified copy or even a copy. Numerous matters, we have to show counsel order in his own favor to read in court. It's all extraordinary. I've been lawyer in the bar for many years, so has Justice Raman.
It will not be repeated.
When some order is even half a line in our favor, we'll keep that order with us.
It will not be repeated.
Here, nobody is bothered.
It will not be repeated.
And they don't even know
my
what
part.
it's supposed to do. We give specific directions that this should be done by so and so within this date. The best thing is don't keep a copy of the order itself.
Yes.
Then you can turn around to the court and say which order, who, what.
It will not be repeated, my lord. Sorry, my lord. On my part, it will not be repeated.
Basically, you are telling us don't work so hard. But we have a bad habit of working hard. That's the whole problem.
But in this case,
we have a very bad habit. A habit we are not able to get rid of.
In this case, the respondent put 23 years of service of your lordship.
What have you said? 8th May. Replies will be filed with the state to the writ petition. 24th April 2023 and rejoined thereto before 8th May. No further time will be granted for that purpose. The learned single judge is requested to proceed with the matter on merits and endeavor to dispose it off as expeditiously as possible.
Supplementary list passed or matter item number 28.
Lordship, this matter, single bench matter, Lordship, wrongly listed because it is not a PL, Lordship. Matter single bench, Lordship.
All right, 1 minute. Let's just see what is. No, but you, what is your locus? You're simply a citizen of India.
Lordship.
Your locus, you're a citizen of India.
Lordship.
So how is that? It's obviously PIL.
It is not a many mass interest not there, Lordship. Only grievance is there, Lordship. Order of earlier this petitioner approached this honorable court. This honorable court passed the order to approach the opposite party number 2 opposite party number 3 lordship make an inquiry. Each inquiry under Annex 2, page 11. He found that person opposite party number 4.
Sir, this representation
Was pending before opposite party number 3 by annexer lordship 4, page 14.
Okay, the petitioner's representation shall be examined by opposite party number 3, Collector Badrak, and after notice to the petitioner and opposite party number 5 and giving them a hearing. An appropriate order shall be passed not later than 1st May and communicated to the parties not later than 8th May. The consequential action shall also be taken on the basis of such decision without waiting for further orders. The court clarifies that it is not expressed any view in the matter.
Item 52.
What's your representation pending?
Pastor matter item number 52.
Sir, 52. 52 I have supplied the cover judgment, my lord. Regarding audit report, my lord, demand notice has been raised on the basis of the audit report, my lord. Weekly list.
Item number 1.
With your lordship's permission, I fully apologize that I'm doing. I have certain matters with your lordships in the weekly list, but I have a special bench matter at 2:15.
Okay.
If your lordship can accommodate me for today.
Which are those items, sir?
Item number 5, 47, 61, and 140.
All right. All right.
Very grateful.
Item number 1.
Yes, sir. Sorry. Yes. Lordship, I have prepared a small note, your lordship. Writ petition is against the award dated 4/2/2010, passed by the Land Industrial Tribunal Bhubaneswar as at Annex 3, page 14, in directing reinstatement of the workman without back wages, but granting leave to the management for conducting fresh inquiry and to pay him subsistence allowance during the period of suspension. Award has been stayed by this Honorable Court by the order dated 14/10/2010. Employee having expired during the pendency of the writ petition, legal heirs have been substituted as per the order dated 3/4/2013 and 9/4/2017. The deceased employee worked as a branch manager of the Bankiso Lamps, a primary cooperative society of the petitioner bank. 6/2/88, employee was suspended by the management. It is a part of Annexer 1, page 8, the indication. 10/5/88 and 3/5/89. Charge sheet and additional charge sheet were issued to the employee being found to have committed serious misconduct in employment. An inquiry conducted with participation of the employee, and most of the charges were established. 24/8/95, employee dismissed from service with suspension period being treated as such. Then 27/5/1997, order of reference. You will also have quoted at page 3, para 5 of the writ petition.
Employee examined himself as WW1 and MW1 was also examined for the management. Deposition of MW1 is at annexer
What is
1
this amount
page.
working out to, sir?
My
What is this amount under 33C2 working out to?
lord, 33C2 application, your lordship.
What is the amount
Your
claimed
lordship.
under that?
Your lordship. The amount, your lordship, is, that was, I was going to that, your lordship. Your lordship, it is 84,915, your lordship. I was just suggesting, your lordship.
84,000?
Yes.
And for this you're fighting?
No. This is relating to subsistence allowance. I am against the reinstatement order without back
Where's the
wages.
question of reinstatement, sir? He's already superannuated, you know that.
Yes.
And now he's also died.
That is exactly I am going to
died.
No, that is exactly just time to point out, your lordship. Is this award may be kindly be modified till the date of reinstatement, I mean superannuation, whatever wages will be there, and the substance
What is
allowance.
the wages? Have you calculated?
That only can be done. Nothing else.
What have you calculated the wages, sir?
3 year something period, your lordship.
Sir, your
It will be around 1.5 lakhs, your lordship.
Mr. Nandi.
Yes,
madam.
Have you calculated? How much is your client owed? Have you calculated?
Yes, madam. That I have not calculated that.
That you said yes.
No,
Then you
madam,
said
the
no.
last pay was only
755, your lordship.
755 for 3 years. Yes.
You are saying you are busy, you are sitting idly, you sit and calculate. Basically, you're telling us. You have no work, sit and calculate. You don't have to calculate.
I am not.
Your client has to get some money, you're not worried. Very good. How much is it, sir? 1.5 lakhs.
1.5 lakhs I have calculated. It is up to your lordship.
After how many years of litigation will he get 1.5 lakhs, sir?
Your lordship, it is 2010 matter, your lordship.
No. Matter is 10. He was dismissed from service in 1995.
95. And the unfortunate part is that, your lordship,
his family is going to get 1.5 lakhs.
No, sir. There is
What
only
a travesty,
catch, your lordship.
What a
has happened?
travesty. Yes.
Only because after the date of superannuation, there cannot be any reinstatement. That is my allegation. I mean, affirmation, your lordship.
What
Only
is the
that
big
much,
thing,
your
sir?
lordship. Nothing more.
If you had told this to the court on the first day, this would have been over.
And your lordship, there are, as it appears from the legal
So when
layers,
will you deposit this?
2 wives, your lordship.
When will you deposit this 1.5 lakhs?
I'll deposit, your lordship.
When?
Your lordship may grant me 4 weeks, your lordship.
All right, Mr. You see, the challenge in the present petition,
yes,
by the management is to an award dated 4th February 2010, passed by the Industrial Tribunal Bhubaneswar.
Yes.
In ID case number 139 of 2000.
Yes. 139, 2008.
Holding that the dismissal of the opposite party work from service with effect from 24th August 1995 was illegal and directing his reinstatement with back wages. No, without any back wages.
Without any.
But directing payment of subsistence allowance for the period of suspension while giving liberty to the management to hold a fresh inquiry.
Fresh.
Paragraph. During the pendency of the right, even before the reference could be taken up, on 1st August 2006, the opposite party superannuated. And therefore, by the time the award was passed, the question of reinstatement did not arise.
Yes.
Paragraph. During the pendency of the present petition, an unconditional stay was granted of the impugned award by this court on 14th July 2010 itself. Full stop. The opposite party expired, and by order dated 9th April 2017, sorry, 3rd April 2013, his legal representatives were brought, bracket LRs, bracket were brought in record. Thereafter, the petition has been pending. Full stop. In the meanwhile, on 28 June 2010, Miss Case number 42 of 2010 had been filed before the Industrial Tribunal, Bhubaneswar.
Labor Code Bhubaneswar.
That's Labor Code Bhubaneswar for
computation of the subsistence
amount,
allowance.
yeah, realization of the amount due under the award. Paragraph. Having heard learned counsel, Mr. N.K. Mishra, learned senior counsel for the petitioner, and Mr. Nandi, learned counsel for the opposite party, and having perused the impugn award, the court is of the view that with the extremely limited relief granted to the workmen, and with there being no possibility of any reinstatement or even a fresh inquiry, the award does not call for any interference at this stage. Full stop. When asked what the amount due to the workman would be, Mr. Mishra offers that it works out to rupees 1.5 lakhs as of today. Paragraph. With the dispute having been pending for over 28 years, it does appear to this court that the sum of rupees 1.5 lakhs is indeed grossly inadequate. Stop. Nevertheless, with the workman not having asked for any further sum, it's not possible for this court to grant any enhanced amount. Full stop. In the circumstances, it's directed that the petitioner management will deposit in this court or bring to this court or deposit before the next date with the registrar a demand draft favoring the wife of the deceased opposite party. The sum of 1.5 lakhs.
Your Lordship, in favor of the Honorable Registrar, Your Lordship, Land Registrar.
No. It has to go to the.
There are two wives, Your Lordship. That is a Your Lordship. Your Lordship sees the legal heirs. Legal heir number 1A, widow, and F, Your Lordship, second wife. As per the legal heir certificate, Your Lordship.
I have met party 10 persons.
Yes. Then as per the legal heir, I have submitted.
Proposed party 1 to 10.
Okay, in the favor of the registrar in this court. List in the regular list on Third April.
Yes.
Weekly list item number 3.
Item 3, Your
Item number 3.
Your Lordship, beg your pardon, I am appealing for the opposite party workmen.
Yes.
Your Lordship, kindly take up the sub item first. That will serve the purpose of the first item also. Second sub item, that is WPC number 17126 of 2012.
Your Lordship, there are two items, Your Lordship. One is relating to the award under section 10(1), Your Lordship. The other one is relating to the order passed by the section 33C2, Your Lordship, the Labour Court, Your Lordship. So I have prepared a composite facts of the case and also the documents which are required for assessment of the two cases, Your Lordship. Your Lordship, Pitson establishment was a steel industry but has since been inoperative since November 2010. This is the most important factor which I want to indicate, Your Lordship. Disputants were engaged under two contractors in the petitioner factory, namely Ramesh and Co. and Mrs. Naik and brothers. 2004-5 situation of strike and lockout arose, which resulted in assault of the manager of the factory in February 2005. 2/5/2005, 10 persons claiming to be direct workmen of the petitioner
referred a claim under section 33C2 for alleged unpaid wages from 1/9/2004 to 18/1/2005, bonus and earned leave in ID miscase number 64 of 2005. This is relating to second case, Your Lordship. Annexer 1, I have enclosed as Annexer 1, Your Lordship. The claim.
Past case.
It is first. I'm sorry, sir. This is the first case. I'm sorry. Stand corrected. Petitioner filed its so cause resisting the claim on the ground of lack of employer-employee relationship and the other grounds. Contract laborers did not join the contractor employer and raised a dispute alleging lockout with effect from 19/1/2005. 23/11/2005, conciliation having remained inconclusive, failure report was submitted. Copy enclosed as Annexer 2, Your Lordship, to this compendium, Your Lordship. 9/2/2006, order of reference registered as ID case number 3 of 2006 in the matter of alleged refusal of employment by lockout with effect from 19/1/2005 to 45 disputants. 12/9/2006, statement of claim filed by the disputants in the matter of claimed lockout. Then 14/3/2008, written statement filed by the petitioner management resisting the maintainability of the reference and lack of employer-employee relationship, besides denying the dispute as raised. 2008, Your Lordship, the deposition of the workmen witnesses, I have enclosed as enclosure 6. 2009 to 11, deposition of the management witnesses, also cumulatively enclosed as enclosure 7. Then, Your Lordship, 17/12/2011, award passed in ID case number 3 of 2006, wrongly holding retrenchment with effect from 19/1/2005 and directing reinstatement in service with 50% back wages. Annexer 1 is at page 13 in WPC number 17126.
So how much will each of them receive? How many workmen are still there?
45 disputed workmen were there.
No.
Contract labor.
As of date, how many are there?
All
of them are there or only some of them are there?
No, some of them have expired, Your Lordship.
How many of them are there?
Out of 45, 39 have filed their affidavit before this honorable court.
39. And how much is each of them due? What is due to each of them?
Your Lordship, there varies their wages from 50 to 75 rupees. Each of them, they are working in different capacity in that organization.
Sir, you want us to sit and calculate or you?
I made it calculate. But after that, kindly peruse the order of this honorable court on that is 18th October 2012. That the stay was operated of award in compliance of the 17B. They did not file any affidavit. After a Lordship's order, 19/7/2022, they directed to file the affidavit, the Lordship's order. After that, on 19 October 22, there was a adverse reference was made to the petitioner that they must file the 17B compliance. Now, they filed an affidavit on 11/9/11/22, filed that they are now unable to comply the 70B of this act, which is a very mandatory provision.
Correct.
So now they are coming forward to file an affidavit at flag 45. They have given some reason, and flag 46, I have filed objection to that affidavit.
No 17B paid.
No, my lords. No, fairly, I must pay.
That goes, sir. The entire thing goes.
Actually, what has happened, Your Lordship, I have indicated since 2010, the factory is known, it is now ground zero, Your Lordship. And unfortunately, the managing director also expired in the meantime, Your
So
Lordship.
just imagine all these workers are at the lurch then.
But I was just indicating the lot. A lump sum compensation, I was also indicating to my learned friend, so that 45 persons can be benefited. I can talk to the management so that it can be done. All the cases can be composed.
Calculate, sir.
Yes, that is what I was thinking. You know,
that's the least that can happen then.
My lord,
bring a chart.
Maybe the decisions.
Council for the workmen will prepare a chart indicating what amount is due to each of the remaining workmen in terms of the impune award, and file it along with an affidavit on or before 3rd April 2023 with a copy to Mr. Mishra, learned senior counsel for the management.
Indicate Nitish, Your Lordship.
Mr. Nitish. Sorry, learned counsel for the management.
Yes.
List on 10th April.
10th
Can it be a little more, Your Lordship, so that I can talk to the management?
Lordship,
He gives the date and I'll give the copy.
no,
I'll talk.
no, my lord, that's, I think it's convenient.
1 week more, Your Lordship. 10 days, Your Lordship. will give.
Or at 17th April.
17 days. Yes. Yes. That'll fine.
Then keep the file.
Great.
All right. Mr. Mishra, wherever you think.
Yes, I'm there, Your Lordship. I'm for the workmen, so that they must get something.
Something. I'm
Yes,
waiting
yes,
for so many years.
Yes. Right.
Weekly list item number 6.
May I please, I am filing one affidavit, my lord, today and sought copy to government. That is on a wrong. That
May I
and
submit
written
one?
note. My lord, this
Lordship
is,
may kindly see, in this case, this is the second round of litigation. After the Honorable Court remanded the matter to ADM, ADM has cancelled. That is impugned in this second litigation.
but my lord,
And just admittedly, what he has stated in the the written note of submission, the impugned cancellation is on the ground of fraud. Now he wants to make out a point that this element of fraud, which the ADM has found in the impugned order, does not constitute the case of fraud.
case of fraud, because
That
my
is
lord,
the only case. Sahan's case is squarely applicable.
no, my lord, not
But he
applicable.
says factually it does not constitute. That your lordship is to decide, consider. Because in fact finding is there.
Yes.
And that fact finding
Yes.
is now challenged in this
Yes, sir. I am, my lord, I am filing the written note and affidavit.
this is the case.
That the
You
finding
justify
of
that
fraud.
factually it doesn't constitute a case of fraud.
My lord, the name of the father of the lessee, original lessee, is that is Madhava Parida. That is reflected in our ROR filing RSD Annexure 2(1), my lord. The name of the father, Madhava Parida. But ADM on a wrong finding, name of the father, that Kamudaya Parida, son of Brahmara Parida. Dear Lordship, kindly see page 16, Annexure 3. Last para. That one, Kamudaya Parida, son of Brahmara Parida. That is the finding of the ADM. I am my vendor name is Kamudaya Parida, but son of Madhava Parida, not my lord Brahmara Parida. On that wrong finding, ADM has cancelled the lease. I am obtaining from 10 numbers of Pata Kamudaya Parida, son of Brahmara Parida, 10 numbers of Pata I am from the Bhulekha, I am downloaded 10 numbers of copy. But no land in Kamudaya Parida, son of Madhava Parida, I found from the Bhulekha. Last week I have downloaded for 10 numbers of RORs. On a wrong finding and the wrong
No, that's neither here nor there, sir. Just come to read the impugned order.
Yes, my lord. I am reading impugned order.
Page 21.
No, not my lord. From first para, my lord.
No. We've read all that. You come to page 21 now.
21.
Issue number 1.
Issue number 1.
Yes. That 21. When the Tahsildar Bhubaneswar did not feel to proper to submit the report, implies to the order of regional court.
Where are you reading,
For
sir?
better reply to issue number 1.
21.
Page 21 of the writ petition.
Writ petition, yes. Issue number 1, that is 20, page 20. For better reply to issue number 1, conjoint examination of both issue 1 and 2 absolutely necessary. Therefore, it is indispensable on my part to examine as whether there is any willful suppression of material fact that led to settlement the case land in favor of Kamdeva, treating him as a landless person or more particularly landless agricultural labor. Examine the lower court case record bearing WL case number 983 of 1974 along with WL case number 1796 of 74 where Tahsildar Bhubaneswar has passed the combined order including WL case of Kamdeva. From the case record, it is revealed that the ex-lessee made application undated to the Tahsildar Bhubaneswar stating therein there he is a landless person and therefore government Westland may be settled in his favor in village Andharwa for agricultural purpose. Revenue Inspector Chandaka at the time of settlement of the case land in favor of Kamdeva and had reported that Kamdeva along with others members of his family own no land in village Andharwa.
Before proceeding with the revision proceeding, in obedience to, to the kind order of Honorable High Court, Tahsildar Bhubaneswar was requested to submit field inquiry report as called for in letter number so and so and so and so. There are 7 numbers of letters, my lord, categorically mentioning therein that this matter demanded by the Honorable High Court is pending for disposal. But till date, disposal, no report is received from the Tahsildar Bhubaneswar, who will get benefit from this callous attitude of lower revenue officers when Honorable High Court have categorically shown concern in case of Saroj Sahu versus ATM Khurda about the settlement of government lands made irregularly and fraudulently in Bhubaneswar Tahsil. Answer is open and clear. When the Tahsildar Bhubaneswar did not feel it proper to submit the report, compliance to the order of
in compliance.
In compliance to the order of this revisional court, it was incumbent upon me to decide the matter within the ambit of law with utmost respect and regards to the order of Honorable High Court in letter and spirit. Therefore, I feel it proper to take the help of Bhulekha from Government of Orissa website, where I found 7 number of RORs showing landed property owned by Kamadeva and others. In order to ascertain it more accurately, leave reserve officer of ATM Bhubaneswar was deputed to Bhubaneswar Tahsil record room to verify.
1 minute, sir. 1 minute.
Yes.
So this seems to be a bit odd. See, the Tahsildar is supposed to give a report. He doesn't give a report.
No, that is why the ATM
So this
himself
man goes
has
on the net.
conducted-
No, he goes on the net and tries to find out how many properties are owned by Kamadeva. Now, there could be so many Kamadevas in Orissa.
Yes.
So
No. In that Andharwa village, the same person with the same father's name.
I am downloaded 10 numbers of Kamadeva, son of
He
Brahma.
claims that his father's name is something else.
Something else.
No.
How
He is son of Madhav.
That is.
There's the whole problem. There's the whole problem. So the ADM gets frustrated that the order is not being. He's not able to comply. So he went to the Government of Odisha website where I found 7 RCRs. This is not the way to go about, sir. Yeah, sometimes. And then whether this prior to these properties were purchased prior to or after, we don't know that.
This is property purchased prior to the order. That is why once it was remanded.
No.
No, we are the
This landed properties were these actually purchased prior to.
Yes, my lord. Now the petitioner before your lordship is the purchaser.
I am the purchaser.
No, not this purchaser. I'm talking of that Kamadeva.
Kamadeva is the original lessee.
Correct, sir. He claimed to be a landless person.
Yes, my lord.
This person says, I went on the website, I found 7 more properties,
in that same village.
So on the date that this lease was granted in favor of this Kamadeva, whether this Kamadeva already had property.
Yes, I understand. That is the record of right which we got from the ADM got. That is old records.
Which year we don't know.
Not old.
See, the
that
point
is not.
there's
There is no
details
such
at all. Whether these RORs pertain to this year earlier to or later to the original lease granted in favor of Kamadeva.
May I suggest one thing to your lordship? Your lordship may direct the ADM to again call for a report from the concerned Tahsildar and pass necessary orders.
Right. All right. You say a perusal of the input order dated 7 November 2012 of the Additional District Magistrate Bhubaneswar reveals that when a report was called from the Tahsildar by him, he did not receive any such report. Full stop. The ADM then took upon himself to go on the Government of Odisha website with the help of single quotes Bhulekha. Full stop. There he found 7 record of rights, bracket RORs, showing open quotation, landed property owned by Kamadev and others, unquote. Then he asked a leave reserve officer to verify the land particulars, open quotation, recorded in favor of Kamadeva and others, unquote. So she then filed a report giving the khata numbers of 7 properties, open quotation, recorded in favor of Kamadeva and others, unquote. Paragraph. The difficulty with the above exercise is that it is not known whether the single quotes Kamadeva is in fact Kamadeva Parida, son of Madhav Parida, who according to the petitioner is her vendor. Full stop. Secondly, it is not known whether all the RORs in fact stand in the name of Kamadev Parida. And thirdly, whether those properties were purchased or possessed by Kamadeva Parida prior to the
grant of
the lease in question. Full stop. Paragraph. Since there are these many questions that arise, the court considers it necessary to require the ADM to hold a fresh inquiry into the matter with the assistance of whatever records are now available with the government.
And by calling for a report from the Tahsildar.
And by collecting a report from the Tahsildar. Full stop. Copy of all these, a copy of such report will have to be furnished to the petitioner to give her an opportunity to meet the case emanating from such report.
Yes.
Full stop. Then let this go, sir.
Yes.
The impugned order dated 7 November 2012 of the ADM is accordingly set aside. Right in the beginning, you say the petitioner has handed over an affidavit of the petitioner enclosing copies of an ROR.
Where Kamadev
It's taken on record. Then this order.
Yes.
The matter, the impugned order dated 7 November 2012 is set aside. And revision case number, lease revision case number 620 of 1998 is restored to the file of the ADM Bhubaneswar to undertake the above exercise. It will now be listed before the ADM Bhubaneswar on 24th April 2023, on which date the petitioner will appear along with a downloaded copy of this order. The ADM will then proceed in the matter as directed by this court and pass a fresh reasoned order within a period of 4 months thereafter. Till such time, status quo as of today shall be maintained.
Yes.
The petition is disposed of.
Weekly list item number 10.
My lord.
Yes.
I'm a district unit of the National Party BJP, my lord.
The whole load of people who are your friends, sir.
My lord,
on the other side, last time there was
so many lawyers were appearing in this case, but
today also cases are not, my lord, to be tagged. Other cases are not also tagged. And the government has not also filed the.
What happened? They gave a whole list last time.
On those cases.
They've come, but not shown in the list. Ask them to show it. So we'll call it on Monday, sir.
Yes, my lord.
So next week we'll call it.
Some of the lawyers are confused whether this will be taken up today or not. So it may be taken up in the regular list on Monday or
Monday onwards. Next week. We'll show all the matters and call it out next week, sir.
My lord, my humble prayer is government has not counted my prayer, my lord, the pleadings, my lord.
If they've not, sir, then you take advantage of that.
My lord.
Okay. Item number 11. Weekly list item number 11.
May please, madam.
This is a matter relating to cancellation of lease that was granted in favor of the original lessee, that is Ramakant Naik. That has already ended in quashment. I'll just point out few facts for your lordship's kind consideration, and then whether this petitioner will be entitled to your lordship's kind consideration so far the relief claim is concerned is not. But the lease was granted in favor of one Ramakant Naik in 1973. 82, after obtaining due permission, he disposes of the property in favor of one Vishwanath Baliar Singh. Now, Vishwanath Baliar Singh in turn, in the year 1988, disposes of the property in favor of one Suresh Chandra Ratha. And thereafter, in the same year, the property comes to the hand of the present petitioner by way of a sale deed. Now, the entire property is of an area of 1 acre. The petitioner has purchased 250 decimals. So there are 4 purchases in respect of the property in question. Now, my lord, he also, my lord, after sale deed, all these sale deeds, your lordship knows under the Registration Act also, the title of the parties are verified and even permission was granted to the original lessee also while disposing of the property. Now, after all these things, subsequently it came to light that on 21/7/87, the ADM, in exercise of power under 7A3, has cancelled the lease that was granted in favor of the original lessee. Now, that came to be challenged by 2 other purchasers, because I submitted it for lordship, there were 4 persons of 250 decimals each. 2 other purchasers came to reasonable court challenging in the writ petitions, and the order of the land ADM was quashed. Matter was remanded for consideration. This petitioner had also filed a writ petition, but in view of the fact that the order was quashed, he withdrew that writ petition to pursue his remedy for the settlement authority. Now, post facto the quashment, this order came to my hand later on, and I may be pardoned, I have not been able to make it on affidavit and adequate copies. But the learned ADM holds that the provisions of the OGLS Act is not applicable because it was not a lease granted under the OGLS Act, and accordingly restores the property in favor of those 2 persons who had moved reasonable court, whose order, my lord, I have annexed at page 39, my lord, annexure 8. Now, my lord, I showed these 2 orders to the settlement authority, saying that my property also should be recorded in my name because it was there as such. But all along it was never, only it came to light later on that in 87 it has been cancelled, which was to the knowledge of none. And fact remains that order has been quashed, effaced by this noble court in 2 other writ petitions. Now, my lord, fact remains the settlement authority have rejected my claim and have directed recording of the land in favor of the government under Abada Ojogya on Avadi status. My lord, if your lordship pardons me, my lord, I am extremely sorry that I have not been able to make adequate copies of this, and I have not been able to file it through affidavit. Only with your lordship's kind permission, may I just draw your lordship's kind attention to the last, my lord, I am extremely sorry, my lord, I am filing it this way, I apologize, my lord.
No, but even he doesn't have a copy then.
I'll give a copy, my lord. The whole difficulty is I thought of saying that stay on board, but I said since I had once already said.
No, you make copies, sir. Otherwise, he cannot also.
So he said 7A3 is not applicable. Now I am in a, my lord, absolutely in a position nowhere because of no fault of mine. And the third person, I do not know, it might have been also restored in his name. So only I am the only person who remains out of the 4 parcels of land.
Anyways, make copies and we'll stay on boards. Monday.
My lord, may I submit one thing to your lordship? Common order passed against 4 persons. 2 of them preferred writ application, and the quashment order of this honorable court is only in respect of the petitioner of that particular
That is not the language employed.
Just a minute. In respect of the property which they purchased from the original lessee, the order was cast and it is not quashed. It is remanded back for fresh investigation, and fresh inquiry was made, and whatever the order was passed. But only thing is that he, so far as the original order of ADM is concerned, he did not challenge it. His matter was never remanded by the honorable court to the ADM. So he cannot take advantage of the orders which was passed in favor of other 2 purchasers. That is my preliminary.
ADM's order, has he not challenged here?
No, he has not challenged. No, let me just clarify. My learned senior could not possibly hear what I submitted. But may I just, with your lordship's kind permission, point out that annexure. The order was cast. I filed a writ petition before your lordship, thinking that since the order has been quashed, I sought permission to withdraw to pursue. It is not that page 6 of the writ application, paragraph J, your lordship may kindly see. It is not that I had not filed a writ petition. I had also filed a writ petition, and so far as the order of quashing is concerned, no language employed that it is confined to the petitioner, but that was my misconception. That is what I beg to submit. It is not that I had not challenged your lordship.
He has challenged. We withdraw the writ petition.
Yeah, once you withdraw, then it is no challenge.
No, but the fact
that is a person.
My learned senior should not just oppose for the sake of opposing. What I humbly, I will always, my lord, make a prayer if your lordship. Your lordship can also delegate me. And the ADM holds the 7A3 is not applicable, your lordship.
In this writ petition, you have not challenged the ADM's order.
My ADM order I have challenged, but I cannot help it because that was withdrawn. Your lordship will see.
No. In this writ petition, sir, you're only coming against the ASO's order here.
True it is, my lord. What I humbly beg to submit, your lordship says there has been a remand that he holds that 7A3 is not applicable, my lord. And then he says, I restore in respect of these two. That is the catch, my lord, I understand.
Even thereafter, since I don't know that withdrawal order, did you reserve liberty or you just simply withdrew?
My lord, the whole difficulty is I tried to find out from the local, the previous lawyer, the documents I could not get. I tried.
Give us a writ petition number. We'll take it out. You give us a writ petition number.
Well, that is WPC number 14915 of 2012, paragraph J, page 6 of the writ application I have mentioned.
14915 of 2012. So let's get a copy.
I also tried from 4 sources to get the documents.
Now we'll check it. Within no time we'll get it.
And one more thing I beg to point out. Now my learned senior must also understand that may be a misconception. But here is a deprivation of property for a misconception where the ADM holds that it is not applicable. I beg to draw your lordship's kind attention to this. It is not a case where my bona fide is not there. My bona fide is there. The council thought,
examine that order.
So my lord, and he has said that it is 7A3 is not applicable, my lord.
And we'll call it on Monday. We'll get that order record.
Item number 12.
Your Lordship, I am appearing on behalf of Mr. S.B. Jana. Your Lordship, in this matter, the Law and Labour Court held in its finding that the termination is neither legal nor justified. But in issue number 2, it mentioned that in lieu of the reinstatement and back wages, only compensation that is in tune of rupees 2 lakh has been awarded. But your Lordship, my prayer was for the reinstatement and payment of full back wages. Your Lordship, kindly have a glance. In para number 8 of the impugned award of Law and Labour Court, Bhubaneswar.
Page 23. Page 23.
Page 23. The first party management having suppressed material documents to report the claim of...
Have you got back in service?
No, Your Lordship.
Why?
Your Lordship, the Law and Labour Court only directed that is 2 lakh rupees in lieu of reinstatement and back wages.
Did you get this 2 lakhs or you did not?
No, Your Lordship.
My lord, we had paid that amount, my lord.
When?
We had paid that amount, my lord.
When?
My lord, in 2005, my lord, by the check dated 6/5/2015, I had sent the check, my lord, to the workman, my lord.
Has he got encashed?
My lord, we had sent it, whether he has...
You know whether it's encashed or not. Say your bank account will tell you it's been encashed or not.
No, as per my instruction, my lord, as to comply with entirely comply with the order of the Honorable Law and Tribunal, Labour Court, my lord, we had sent this check.
Sending the check is not, sir. When we say you have to pay,
Your Lordship, kindly have a glance. And
my lord,
has he got paid or not?
No, regarding that, my lord, I will take instruction.
Right. Kindly have a glance in the...
So first, let your client get the 2 lakhs at least.
Yes, Your Lordship.
In fact, sometimes I wonder, your workman's lawyer, you're not insisting on him getting money at all. The poor man was supposed to get 2 lakhs when?
Well, in 2014, my lord, his daily wage, the minimum wage was 100.
For the last 9 years, just imagine his plight, sir. For the last 9 years, he has not even the 2 lakhs he has got.
Well, he didn't, if he has not taken it, my instruction is that, okay, we have sent the check, but the proper check from the Bata India Limited, and he might have encashed it. And
all might have, should have, you don't know. He doesn't know, you don't know.
My lord, I will take instruction whether he has, encashed it or not.
Your Lordship, so far as the reinstatement and back wages, Your Lordship, kindly have a glance in the...
Sir, today we'll allow all your petitions. You will be very happy. You will go out of the court. Your client is going to get nothing. You want that situation?
No, Your Lordship.
You have to strategize, sir. You're a young lawyer. You should know your client will go empty-handed. You can walk out saying, very happy, I won a case. Your client will get nothing.
My lord, may I humbly submit, Lord, this type of situation has also arisen before the Law and Labor Court. His daily wage was 103 rupees. And he was given a 2 lakh in 2014, my lord, given the situation, because he was a temporary employee, my lord, casual worker, my lord. Had he just
Where is this workman?
Being a temporary employee does
Where
not
is he
even-
located? Where is he located now? Have you spoken to him?
Your Lordship, only that he instructed me that he had not get any.
Where is he, sir? He's
He had
here,
not get any
outside. Where is he?
Your Lordship,
Where is he now?
Lordship,
This address says Shastri Nagar, Bhubaneswar. Is he there?
I'll take instruction.
You see, President. All right. 2 weeks. Next week after, week after next. All right.
The sentiment to continue.
Not passing any order, sir.
We are not passing any order, it is stay on.
Item number 43. Item 43.
On the behalf of Mr. Arjit Mishra, he is not well, madam.
All right,
I adjourn
next
to
week,
Monday.
next week. All right.
Item number 45. Weekly list item 45.
45, I am for the opposite part number 7 and 8.
None please for the petitioner. Dismiss the non-prosecution.
Item 47. Item 47. Item number 48.
May I please, sir? There is the challenging the tariff order, my lord, regarding the cold storage, which are coming under the agro-industrial tariff after the amendment of regulation 5. That is an authority of the OERs, my lord. My lord, if the order he alleges that in terms of the order he is entitled, my lord. But my lord, that order is challenged in some other petition, my lord. And my lord, if the order is not being complied with, my lord, remedy is available to the consumer under section 42 of the Electricity Act, my lord.
No. Is there any other connected petition?
That is the connected matter, my lord. My lord, senior is 5, my lord. That is the connected matter, my lord. They have challenged their ombudsman order, which is allowed. My lord, that order is on challenge, my lord.
20783
by the licensee, my lord.
20783.
My lord. That they have challenged that ombudsman order, which hold that the tariff order should be implemented and the cold storage should be come under the allied agro-industrial tariff. And thereafter, I have filed that judgment of this. My lord, so far this connected case is concerned, my lord. My lord, some part record I want, my lord, that is not with me, my lord. Lord, next week it may be called, my lord.
All right, next week.
Item number 49.
49, I have got instructions to appear here. It is possibly a single bench assignment, Your Lordship. Disciplinary proceeding.
49 challenging the industrial tribunal award. I don't think.
No,
I'm so sorry, Lord. I'm extremely sorry, Lord. I made a wrong submission. I'm so sorry. It's a discipline proceeding order has been challenged.
Single bench assignment.
So 67B alternate remedy is there.
That I'll see.
No, that Odisha Cooperative Society Act, he has challenged the disciplinary proceeding or punishment in the disciplinary proceeding. Straight to him, Lord, 67B is applicable. He has to challenge the district tribunal. I'm sorry,
I'll see to it, Your Lordship. Keep it on board, Your Lordship, next week.
No, if it's single judge, it has to go to single
judge, your lordship. Single judge has to go.
But in a lighter way, so use the division bench, don't put single bench, bro.
No. How can it be? How can it be? That's the novel idea.
Then appeal is
then nothing will remain. Your lordship. Then nothing will remain. Your lordship.
Then you say for the roster bench of the single judge on 20th March.
20th.
Item number 53.
My lord, judgment is sought upon me, my lord. I want to further examination 53.
45, my lord.
My lord. We'll call it off. 50 is over now. Please stay on boards.
My lord, I want to further time out for examination of examination.
So you'll get it, sir. Next week only.
53.
45.
That will stay on board.
53.
My lord.
That will stay on.
My lord.
Stay on.
Deployed.
Item 55.
Item 55 here, the state was rather supposed to file a counter. If this day for yesterday when it was called, counter they will yes. Blood order dated 27th of June 2022. Counter affidavit be filed within 8 weeks. Rejoinder affidavit there too. No such counter is filed till date.
Yes, Mr. Monty.
Yes, my lord.
55.
Last chance.
The last chance is given to comply with the order dated. Given to the state to comply with the order dated
27th
June 2022. Counter affidavit will be filed within 8 weeks. Rejoinder for the next date. List on.
Ouch.
June.
27th June.
Item number 56.
7 may be taken up on Monday.
Sure.
Not.
Item number 60.
Item 60, my lord, is a state's appeal against administrative tribunal order. The short question here is whether the respondent is liable to get the promotion from 2003 or from 2011 from which he was promoted. That is the short question. My lords may see the impugned order. Which is at page 12, my lords. As admittedly, my lords, we had not filed a counter and it was, the judgment was passed, the order was passed, the impugned order. As may see, para 2, no counter has been filed by the respondents. We have asked the Learned State Council on 6/3/12 to obtain necessary instruction as called for. It is submitted by Learned State Council that in spite of his correspondence, he could not get instruction. As it relates to promotion, etc., we have heard the learned for the applicant and the Learned State Council who make submission based on the annexures of the OA. This case will be disposed of basing on the documents annexed with the IA. And thereafter, Millards, the reasoning of the tribunal.
Ma'am.
No, for the other side.
My lord, may I submit kindly see your lordship's order dated 22/9/2021 and 8/12/2021, my lord. Kindly see for a moment your lordship's order.
As pursuant to those two orders, we have filed our additional compliance affidavits.
On which may I submit one? 22/9/2021.
Yes.
And 8/12/21.
Yes.
Subsequent order.
Yes.
May I submit one?
Yes.
My case was that before tribunal.
Let me submit what the case is.
Let's make.
So what happened to the discipline proceedings? You want to file an affidavit on that?
Yes, my lords, we have filed those two affidavits. It should be on record. My lords, the first affidavit, which is pursuant to my lords orders dated 22/9/2021, that is my lords filed on 7.
No, 22/9 is our date of our order, sir.
Yes, my lords, 7/12/21 we have filed it. And thereafter, my lords, another affidavit has been filed on 11th March 2022.
11th March is here. You got a copy of the 11th March affidavit?
I got. Let me, my lords, take my lords through the impugned order, page 13. As the issue was that there were certain adverse remarks against the respondent in the CCR, and there were disciplinary proceedings against the respondent. Now, in one of the disciplinary proceedings, he was exonerated by the appellate authority. So the impugned order states that because he was exonerated in the disciplinary proceedings, the CCR remarks also gets wiped out. So hence he should get the promotion from 2003 and not from 2011. Now, Milas will appreciate there's a qualitative difference between entries made in the CCR, which is over a period of time and based on confidential information by the author, submitted to the author of such document, and Milas, the disciplinary proceedings, which is specific to the charges, and against the charges, Milas, he has gone. Now, against the CCR also, there is a procedure under the manual which says that it will go up to the government. He has gone up till the government. The government has finally said that, no, we are not expunging those remarks. There is no appeal against that. So therefore, as regards the CCR remarks is concerned, today, my lords, it is crystal clear that for that particular period, the CCR remark stands. And he does not have any, he hasn't filed any appeal against those CCR remarks. What he has been exonerated against is the disciplinary charges. And there also, my lords, there were two disciplinary charges. One, my lords, pertaining to a case in Bolangir, and the other, my lords, pertaining to case in Sambalpur, my lords. My lords, I'll take my lords to page 25, which is Annexure 7. This is again another order which has not been challenged. This order is, my lords, pursuant to the direction of the OAT, because this was his second attempt before the OAT. He had gone before the OAT once. The OAT said that you consider his representation. His representation was considered.
And rejected.
And rejected, my lords. It was rejected, my lords, page 26, if I may read.
It's all right.
Yes, ma'am. So therefore, this also has not been challenged. So hence, my lords, today, that particular period which are filed on page 21, which is the CCR report, which is from the period from 35/2002 to 31/3/2003, those CCR reports, my lords, it says standard of collection of intelligence poor, zeal and industry indifferent, passes responsibility to others. So these are the remarks which have been made against him, and hence the appellant here has decided that for those period, because there were these remarks, so he cannot be promoted. And subsequently has been promoted from 2011.
Yes, sir.
First submission against the punishment which is my learned friend shown on page 26. Against that, I preferred appeal in my preliminary counter. Your lordship, kindly see page 6. I have been exonerated in that punishment.
He does not deny that at all, sir.
No, he has saying in two different proceedings. My lord, kindly see punishment page 26.
So they're not denying that in proceedings you've been exonerated.
He is denying in that proceeding. My lord, kindly see form page 26 read petition. In Sambalpur district proceeding, number 5/6, last person, page 26 read petition. Sorry, Bolangir district 5/6. In view of award a major punishment of Bolangir district proceeding number such and such, the seal cover containing finds of such and such cannot be opened. But in this proceeding, I have been exonerated. I have enclosed the order in my preliminary counter under annexure under A by 2, my lord, in my revision, my lord. Page 7, my lord. In my preliminary, thereafter, which is again shown, my lord, in the CCR, kindly the CCR report page for a moment, my lord, in the read petition, page, my lord, annexure 4, page 21. May I read? Adverse remark passed by such and such Superintendent Police, Sambalpur, for the period 35 2002 to 31 2003. What is the quality of, my lord? Basing on the two cases where I was not the IO, my lord, they have mentioned in the CCR, adverse report, my lord. In Katarbag PS 11, thereafter in 16 column, my lord, in Katarbag PS 63. On that, basing on two cases, adverse CCR have been given, my lord. Prior to that, the charge. Basing on the two cases, PS cases, charge have been imposed on me.
This is not your disciplinary cases, sir. This is some other criminal case.
No, man. The charge in the disciplinary cases as well as in adverse CCR was same, basing on one PS case, my lord. My lord, kindly see the charge, my lord.
Yes.
My case is that since in the charge basing on one same PS case, my lord, since I have been exonerated in the charge.
So there are 2 or 3 comments here, sir. One is passes responsibility to others. That has nothing to do with the PS case.
Since basing on that PS case charge, my lord, kindly see the charge, my lord.
Read carefully, sir.
My lord.
What we are reading now, read carefully.
My lord. Page, my lord. 21, my lord. My lord. Collection of intelligence, my lord. Quality of work. Poor due to his inaction against illegal liquor vendors and anti-socials under Rengali outpost area, they were active and due to group rivalry, counter in murder case by Kattarbaga PS case number 11 dated 21 2023 and case number 63 dated 24/4/3 took place over a span of months, but he could not collect any intelligence to help the arrest of accused till date, my lord. Next, my lord, can you see page 18, my lord, for a moment, charge, my lord.
So, if you break it down, sir, one is passes responsibility to others. That is a separate thing.
Well, can you see for a moment, charge, my lord, page 18, my lord. Mail. SI such and such district is charged with gross misconduct and derogation is due. In middle portion, it has been mentioned that, my lord. In this connection, Kattarbaga PS case number 11 dated such and such under section such and such. In below portion, my lord, Kattarbaga PS 63 dated 24/4/3 under section on the basing on self some PS case. A departmental proceeding was initiated, and in that departmental proceeding, the appellate authority has exonerated me from the charges. My case is that before your lordship, that since I have been exonerated from the charges by the appellate authority, the adverse remark which has shown, my lord, that should not be.
All right. Anything else, sir?
This is my case, man.
All right.
Since I have been exonerated by the appellate authority,
all right,
and we're basing on self some PS case, adverse regards should not
all right.
wiped out. Man.
All right. The state is in file this petition challenging an order dated 17th May 2012 passed by the Orissa Administrative Tribunal, Cuttack Bench, Cuttack, bracket OAT, in OA number 503, bracket capital C of 2012. While directing notice to issue the present petition on 11 September 2013, this court stayed the operation of the impugn order, by which while ordering expunging of the adverse entries made in the opposite parties' confidential character roles, like at CCR. The OAT held that the non-consideration of the case of the opposite party for promotion, from the date when his junior was promoted, is arbitrary. Full stop. The Director General of Police was directed to consider granting promotion to the opposite party to the rank of Inspector of Police with effect from 29 November 2003, the date from which his junior was so promoted. Paragraph. The background facts are that the opposite party was appointed as Sub-Inspector of Police, bracket SI, bracket on 31st January 1990. So for the period from 30th May 2002 to 31st March 2003, the Superintendent of Police, bracket SP, Sambalpur, recorded adverse remarks in the CCR of the opposite party while he was still serving as SI of police. Stop. It is stated that these remarks were communicated to him on 18th May 2003. Stop. The opposite party then submitted a representation to the then DIG of Police, Northern Range, Sambalpur. To stop, the representation was rejected by an order dated 2nd August 2003 of the DIG. Full stop. On this basis, the opposite party was found unsuitable for promotion by the Central Selection Board, bracket CSB, bracket held on 12th November 2003. Paragraph. The opposite party then appealed to the DG of Police on 25th July 2004. Full stop. This appeal was rejected on 21st March 2005. Full stop. Then a memorial to the government was submitted on 15th April 2008, which was also rejected on 27th May 2009. It is stated that the said order dated 27th May 2009 was not challenged by the opposite party in any forum. Full stop. Paragraph. The opposite party filed OA number 17 bracket S 2008 before the OAT Bhubaneswar for a direction, that is representation regarding the adverse entries in the CCR should be disposed of. Full stop. By an order dated 6th December 2008, the OAT directed an appropriate order to be passed within a period of 3 months on his representation. Full stop. The Government and Home Department, by memo dated 6th June 2009, no, you see, on 1st July 2009, the DG of Police passed the consequential order rejecting the representation of the opposite party. Full stop. This order dated 1st July 2009 was again not challenged by the opposite party. Paragraph. Meanwhile, during the pendency of these proceedings, the opposite party was promoted to the rank of inspector with effect from 30th May 2011. Full stop. The reason for his not being promoted from 2003, when it was due, was on account of the pendency of departmental proceedings number 11 of 2003 and 5 of 2006. Full stop. In departmental proceeding number 11 of 2003, the opposite party was exonerated on 10th July 2006 by the appellate authority. Full stop. In departmental proceeding number 5 of 2006, the punishment of single quotes black mark unquote was set aside by the revisional authority by the order dated 10 June 2009. Full stop. On the above basis, it was contended by the opposite party before the OAT that the denial of promotion to the opposite party from 2003 onwards was no longer justified, since he had been completely exonerated in the departmental proceedings. Paragraph. Paragraph. The perusal of the impugned order dated 17 May 2012 of the tribunal reveals Paragraph. The case of the petitioner is that the material on the basis of which the departmental proceedings were initiated was no different from the material that formed the basis of the entries, adverse entries in the CCRs. And therefore, exoneration in the departmental proceedings would automatically result in expunction of the adverse entries in the CCRs. Full stop. On the other hand, in the additional affidavit dated 7th December 2021, filed by the authorities, they claimed that the material on which the CCR was based was different from the one that formed part of the disciplinary inquiry. Full stop. At the hearing on 8th December 2021, this court permitted the learned additional government advocate to file a further affidavit explaining the difference in the materials. Full stop. First, pursuant thereto, an affidavit has been filed on 11th March 2022 by the Additional Superintendent of Police, Cuttack. It is stated therein that in connection with the handling of Qatar Baga PS case number 11, handling of the investigation in Qatar Baga case, PS case number 11, dated 20th January 2003, registered under section 302/34 IPC and 25/27 of the Arms Act. The opposite party did not take any sincere steps and did not collect proper intelligence, as a result of which the accused persons could not be arrested for more than 3 months. Full stop. In the meanwhile, a counter murder took place and resulting in registration of Qatar Baga PS case number 63, dated 24th April 2003, under section 302/34 IPC. Full stop. It was alleged that even after this, the opposite party did not take effective steps for arrest of the accused. And this continued to relinquish this charge of the Rengali outpost on 28th May 2003. Paragraphs. It is stated that the entries in the CCR, however, were based on open quotation personal and confidential information. Full stop. There it was reflected that the work of the opposite party was single quotes poor, and that his attention towards investigation, supervision, and other works was single quotes superfluous. Full stop. He was stated to be open quotation indifferent, and it was stated that he, open quotation, passes responsibility to others, unquote. Paragraph. It is on this basis it is contended that the entries in the CCRs do not automatically flow from the events forming subject matter of the disciplinary inquiries against the opposite party. Full stop. Learned counsel of the opposite party, however, drew attention to the charges in the disciplinary inquiry and submitted that they form the same basis for the entries in the CCRs. Full stop. He submitted that with the opposite party having been totally exonerated in both disciplinary inquiries, but there was no valid basis for retention of the adverse entries in his CCRs. The court is unable to agree with the above contention. Indeed, the entries in the CCRs appear to be on consideration of a variety of factors. To stop, the copy of the CCR placed in record reveals that the adverse entries therein were not based exclusively on the disciplinary proceedings that were undergone by the that were instituted against the opposite party. Full stop. On the other hand, a careful perusal of the entries would show that while there is mention of the criminal cases noticed here and before involving the investigation of which was entrusted to the opposite party, the adverse entries do not necessarily relate to that factor. To stop. In other words, they do appear to have been made on the basis of personal and confidential information. The perusal of the impugned order of the OIT, however, reveals that merely because the opposite party was exonerated in the disciplinary inquiries, it was presumed that there was no justification for the adverse entries in the CCR. So this is clearly an erroneous approach, since in the facts of the present case, it appears that one would not automatically lead to the other. In other words, the exoneration of the opposite party in the disciplinary proceedings and the adverse entries in CCRs are not necessarily related to each other. No, and do not necessarily relate to the adverse entries in the CCRs, which appear to have been based on some independent material and information available with the department. For the aforementioned reasons, the court is unable to sustain the impugned order of the OAT and is accordingly hereby set aside. The writ petition is allowed with no order systems.
May submit one line. You last had dictated the opposite party was the investigating officer, but he was not the investigator, he was the OIC.
All right.
He was not the investigating officer.
All right.
Both the cases.
Weekly list item number 71.
Pardon, my lord. My lord, item number 45, my lord. That was in Adhakora came by running and that matter has been kindly be in board, my lord.
Yes, tell us.
Madam, item number 45, madam.
45.
Madam, giving us to debt charge, madam.
Yes.
My lord, in this matter, what happened, my lord? I tried to contact the petitioner, my lord. He was not well, my lord. Then I don't have any certain instruction what is going on now, my lord, but I am doing this, my lord. Means what happened, my lord? He came with an application was approved by the bank. This
So why should we decide a case without knowing where the petitioner is and what he's doing?
My lord, I tried to contact my lord, but it's an old matter. Mr. Ajit Chaudhary is no more, my lord. Whose matter is this? I tried to contact, but no connection with him.
No, we're not going to unnecessarily sit and decide and write a judgment if the petitioner is not even around.
Then my lord can get me a liberty if
next week you better find out.
Our presence may be noted. I am for calling.
Not passing any orders.
Yes.
Item number 71.
I was the opposite. I'm for the opposite partner one.
But I am also appealing on opposite partner two. Lord, on the last occasion, it my.
Who appeared last time? Who's taken? We don't know. All right. None appears dismissed anonymous. Just note his presence.
Item 72.
Well, 72, two matters is there. First matter has become infructuous matter.
All right. 72 is the first item.
Lord,
Dismissed as infructuous.
Your Lordship may mention the name of Mr. Pradeep Kumar Mahapatra on behalf of I am submitting, Mala.
All right.
But in the second matter, now the engine is not there, but since these are public dues, I think the successor company, which is now Tata Power, they might like to, Lord, step in and continue with the litigation or the collection process.
We don't know.
So
Let them revive it if they need to.
Yes, ma'am. That liberty can be granted.
Yeah,
so
it
that
stated that the petitioner is no longer in existence.
no, it is in companies in existence, but we are not operating in Orissa as of now.
All right.
We were the
petitioner is
agency
no
who
longer
were
operating in
appointed.
Orissa. Full stop. The successor entity has not filed any application to be substituted. Full stop. The petition is accordingly dismissed with liberty to the successor entity to file an appropriate application for its revival in accordance with law.
Name of the Pradeep Mahapatra for opposite party in the another case.
All right. All right.
Two separate order may be passed.
All right.
All right. Item number 75.
75, my lord, made pleasure, lordship. Lordship, the fact of the case is like this, my lord. There is a small strip of land in between the petitioner's house and the public road, my lord. So he usually, my lord, through this piece of land, my lord, he approaches the public road, my lord. The grievance here is, my lord, so far as the prayer of the petitioners is concerned, my lord, he wants this land to be settled in his favor, my lord. With due consideration amount, he is ready to pay, my lord. There was one inquiry upon this land, my lord. There was a report from the government. They said that this land cannot be used as a public purpose. This land can be given to the petitioner. But they have said that this land is costing around 15 lakhs. You pay me 30 lakhs. This was the, my lord, demand by the government. I am ready to pay the, my lord, amount as the market value amount, my lord.
What is the market value, sir?
My lord, now presently they have passed one order, my lord, in 97, my lord. They have said the land value is 15 lakhs. At that point of time, my lord, the report is that
it is at Hoinagar, just adjacent to the secretariat.
My lord, whatever the present price, I am ready to pay, my lord.
What is
Let
it,
them
sir?
cut.
Tell us.
My lord, to that extent, my lord, I need to find out, my lord.
Find out, you keep the demand draft for that amount ready,
My
then
lord.
we pass orders.
My lord, obliged.
I'll do. Right.
Item 78.
78, my lord, my senior has made a statement last occasion. We are trying to settle the dispute outside the court. And now we are calculating the amount what we have paid.
All right.
Let it be
All right.
on the board, my lord.
All right.
Item number 84.
This matter, my lord, may I pray this 1 week after, my lord?
All right. All right.
Item number 85.
My lord, I am for the petitioner, my lord. Here, my lord, petitioner is my lord, entrepreneur, has acquired 120 acres of land for PC culture, my lord. And he is continuing PC culture. In between 120 acres land, some governments lands are lying. And he has also converted in his, he has applied for the to the government, and it is pending with the government for settlement. Your lordship will find Rule 11 to the, my lord, OGLS Act. It is provided, my lord, it is under serial number 14 to the Rule 11, Schedule 2.
Again, no counter filed.
No
My-
counter is not
no
filed.
counter has
He
been
has
filed.
made the application.
I have made application. My lord, I will file another additional affidavit. I have approached the government. Since the rule provides to approach the government, Rule 11, Schedule 2 provides to approach the government for settlement of the land.
As far as my knowledge goes, for getting a lease under the OGLS Act, they have to comply with a format.
My lord,
BA department, it within the BMC area.
no, it is not BMC. It is in a Jamarswa in a Puri remote area.
Sorry. Then he have to call, he has to apply before the collector.
No, my lord. Since it is more than 10 acres, it is provided to the government. And I have applied to the government.
He should apply to the collector. Collector will refer it to the government for consideration.
My lord,
Let
I
him apply. He will.
Counsel for the petitioner.
My lord, I will approach, make a fresh application.
This writ petition with liberty to approach the collector Puri with an appropriate application
Under Rule 11
under Rule 11 of the OGLS rules.
of the OGLS rules. And my lord,
Such
that
application is filed not later than 10th April 2023.
my lord, till then status quo be maintained. I am status quo order is there, my lord. Order is there.
In accordance with law, and an order shall be passed thereon by the government
Well,
within a period of 4 months thereafter.
my lord.
Till such time, the status quo order passed with the court on 30th January 2015 will continue.
Obliged, my lord.
The court clarifies it has not expressed any view on the matter.
Okay.
Item number 123.
My lord, only one line can be added, my lord, with the existing PC culture policy, my lord. That is to be considered under
In
the
accordance
existing.
with law, your lordship.
Yes.
In accordance with law.
My lord.
Yeah, correct.
123, sir.
123.
123.
Where is that Mr. Fayaz?
Yesterday also they are Mr. Feda sent in the court.
No, but you have to tell him, sir, only then he will come. Without him, we can't decide this matter. Wakaf board. Yes, sir. We'll wait.
This writ application is filed by the.
We'll wait for him, sir.
Yes, madam. Yes, I am.
126.
May I please also. On behalf of Mr. Bharat Jali, my lord, he praying for a direction to file fresh representation before the HUDCO OP number 2, my lord, for settlement of the penal interest and about my penal interest, my lord.
I'm for the Paradip Port Trust, my lord.
All right. Counsel of the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation. to opposite party number 2, Hudco, for consideration of the
Went through that Indore development, the Constitution Bench judgment. So as per that judgment, Millards, if the award is not made, then the proceedings wouldn't lapse. The compensation will be granted under the 2013 Act.
So
That is what.
prepared to pay the compensation now.
Yes, since Millards,
That's what he's been asking for. He says, give me compensation under the 2013 Act.
His prayer was to quash the land acquisition and as well.
Now he's saying, give me money under the 2013 Act.
Yes.
My lord, the compensation is to be made under the 2013 Act as per this judgment.
Yes. As I'll just give the relevant paragraph.
Indore development, Manohar Lal.
Para 366.1. Under the provisions of section 24(1)(a), in case the award is not made as on 1/1/2014, the date of commencement of the 2013 Act, there is no lapse of proceedings. Compensation has to be determined under the provisions of the 2013 Act. So, we'll have to rework the 14 lakh which we had. So that has to be reworked.
All right. This petition has been filed by a resident of Mahavir Pada, Bhavani Patna, district Kalahandi, claiming that his land in plot number 1366 of an area of AC 1.17 decimal corresponding to Khata number 15 of Moza, Junagadh, would be acquired under the Right to Fair Compensation and Transparency Land Acquisition Rehabilitation Resettlement Act 2013, bracket, hereafter the 2013 Act. Since the award in terms of section 11 capital A of the Land Acquisition Act 1894, bracket LA Act, was not passed within the time stipulated thereunder. Paragraph. The relevant facts are that the notice under section 4 of the LA Act was issued on 22nd October 2007 for acquisition of the petitioner's aforementioned land. And declaration under section 6 bracket 1 of the LA Act was also issued on 3rd November 2008. Full stop. As far as the petitioner's parcel of land was concerned, the award was passed by the LA collector only on 12th May 2015. That is nearly 7 years after the declaration of section 6 bracket 1 of the LA Act. The above facts are not disputed by the opposite parties in their counter affidavit in the present case. Full stop. No reasons have been given for the delay in passing the award. Full stop. In fact, in para 9, it is stated of the counter affidavit. It is stated that the petitioner was invited to attend the office of the LA collector on 12th May 2015 for receiving the compensation amount on or before 27th May 2015, but that the petitioner did not attend and collect the money determined to be paid to him under the said award. Paragraph. The further fact which is not disputed is that on 1st January 2014, the 2013 Act came into operation and it repealed the LA Act. Full stop. The consequences of the repeal of the LA Act and its effect on proceedings that were still pending as on the date of coming into force of the 2013 Act have been anticipated by Section 24 of the 2013 Act, which reads as under, reproduce the whole of Section 24, paragraph. Section 24 of the 2013 Act now stands interpreted by the decision, the Constitution mentioned of the Supreme Court and Indo Development Authority. Versus Manohar Lal, 2028 SEC 129. Stop. The summary of the answers provided by the said judgment to the various issues addressed therein is provided in para 366 of the judgment, bracket SEC, bracket. Where and in para 366.1, the present scenario has been envisaged, namely the award consequent upon the proceedings initiated under the LA Act not being passed as on the date of coming into force of the 2013 Act on 1/1/2014. Full stop. Para 366.1 reads as under. Reproduce. Paragraph. It is now, therefore, that in a scenario where no award is made under the LA Act in respect of proceedings initiated thereunder prior to coming into force of the 2013 Act, that is prior to 1st January 2014, there would be no lapse of the land acquisition proceedings, but open quotation, compensation has to be determined under the provisions of the 2013 Act. Would stop and quote. Paragraph. Therefore, in the present case, the compensation amount for the land acquired, for the land of the petitioner that has been acquired by the government of Orissa, has to be determined in terms of the 2013 Act. Full stop. It is now accordingly directed that the matter will once again be placed before the Land Acquisition Collector Kalahandi, bracket opposite party number 5, for redetermination of the compensation payable to the petitioner in terms of the 2013 Act. Full stop. It will be taken up. It will be taken up by opposite party number 5 on 1st May 2023, on which date the petitioner will appear with a downloaded copy of this order. Full stop. After hearing the petitioner, the opposite party number 5 will pass an appropriate order redetermining the compensation amount payable to the petitioner not later than 1st July 2023. The payment of the determined compensation amount should be made to the petitioner strictly in terms of the 2013 Act within a further period of 8 weeks thereafter. The petition is disposed of the amount.
My lord.
Right in the beginning, the substitution application will have. Right. All right.
I know item 71. When the matter was called, I was not there. My lord, I have sought for instruction about
Stay on board then. All right. Stay on board.